Good morning, one and all. I welcome all the respected judicial officers for this session. I also welcome Sri Madhukar M. Deshpande, Advocate Bengaluru, for the session. I request sir to address our officers on Bharatiya Sakshya Adhiniyam 2023, overview, additions, deletions, modifications, and reorganization of chapter and sections, role of a trial judge, analysis of electronic evidence and its admissibility under BSA with reference to Arjun Pandit Rao Kotkar versus Kailash Rao Kushan Rao Goryantal. Over to you, sir.
ನಾನು ಕನ್ನಡದಲ್ಲಿ ಮತ್ತು ಎರಡು ಇಂಗ್ಲೀಷ್ನಲ್ಲಿ ನನ್ನ ಒಂದು ಲೆಕ್ಚರ್ ಸೀರೀಸನ್ನು ಪ್ರಾರಂಭ ಮಾಡೋದಕ್ಕೆ ಇಷ್ಟಪಡ್ತೀನಿ. ಬಿಫೋರ್ ಐ ಸ್ಟಾರ್ಟ್, ದಟ್ ಈಸ್ ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ 2023, ಐ ಫೀಲ್ ರಿಲೇಟೆಡ್ to address. The reason is that some of my colleagues, they practice but here they are the for whom I had argued the matter extensively. I had head of the High Court of Karnataka. ನಿಂತ್ಕೊಂಡು ಮಾತಾಡೋದಕ್ಕೆ ನನಗೆ ಕೊಟ್ಟಿರುವಂತಹ ಸಬ್ಜೆಕ್ಟ್ ಏನಿದೆಯಲ್ಲ, ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ, ವೆರಿ ಇಂಟ್ರೆಸ್ಟಿಂಗ್ ಲೆಜಿಸ್ಲೇಷನ್. And most of the time we advocate, we have our own philosophy, ideology, and most of the time the unlearning is the process, and that particular unlearning which I can see in you, that is not, you cannot find in us. So while explaining the Bharatiya Sakshya Adhiniyama 2023, you may feel that either I may be glorifying it or I'm too much criticizing it because of our philosophy, because of our ideology. So we cannot remain impartial. A judicially trained speaker who is a judicial officer, he will remain neutral, then he will explain it. Whereas a speaker who is an advocate, he will try to glorify. ಕನ್ನಡದಲ್ಲಿ ಹೇಳಬೇಕು ಅಂತಂತಂದರೆ, ನಾನು ಪಕ್ಷಾತೀತವಾಗಿ ಒಬ್ಬ ನ್ಯಾಯಾಧೀಶನಾಗಿ ಮಾತಾಡೋದಕ್ಕೆ ನಮಗೆ ವಕೀಲರಿಗೆ ಬಹಳ ಕಷ್ಟ. ರೀಸನ್ ಏನು ಅಂತಂತಂದರೆ, ನಮ್ಮದೇ ಆದಂತಹ ಒಂದು ತತ್ವ ಸಿದ್ಧಾಂತ, ಅದಕ್ಕೆ ಅನುಗುಣವಾಗಿ ನಾವು ಪ್ರಾಕ್ಟೀಸ್ ಮಾಡ್ತಾ ಇರ್ತೀವಿ, ನಮ್ಮ ವೃತ್ತಿಯನ್ನು ನಡೆಸ್ತಾ ಇರ್ತೀವಿ. ಅದಕ್ಕೆ ಅದನ್ನೇನಾದರೂ ಆ ರೀತಿಯಾದಂತಹ ಗ್ಲೋರಿಫಿಕೇಷನ್ನು, ವಿಪರೀತವಾದಂತಹ ಕ್ರಿಟಿಸಿಸಮ್ ಏನಾದರೂ ಇತ್ತಂದರೆ ದಯವಿಟ್ಟು ಕ್ಷಮಿಸಿ. ಈ ಒಂದು ಪ್ರಿಫೇಸ್, ಈ ಒಂದು ಒಂದು ಮುನ್ನುಡಿಯಿಂದ ನನ್ನ ಒಂದು ವರ್ಗನ ಪ್ರಾರಂಭ ಮಾಡೋಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. ನನಗೆ ಕೊಟ್ಟಿರೋದು 2 ವಿಚಾರ ಇದೆ. ಒಂದು ಏನು ಅಂತಂದರೆ ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮ 2023 ಬಿ ಎಸ್ ಎ ಹೇಗೆ ನೆನ್ಪಿಟ್ಕೋಬೇಕಪ್ಪ ಅಂತ ಅನ್ನೋದು ಒಂದು ಸ್ವಲ್ಪ ಡಿಫಿಕಲ್ಟ್ ಟಾಸ್ಕ್. ಅದು ನಾವೆಲ್ಲರೂ ಸಹ 1990 ಅಥವಾ 1995 ಆ ಟೈಮ್ನವರು. ಸೊ ಬಿ ಎಸ್ ಎ ಸೈಕಲ್ ನೆನ್ಪಿಟ್ಕೊಂಡ್ಬಿಟ್ವಿ ಅಂತಂತಂದರೆ ಸೊ ಈಸಿ ಅಂತ ಅನಿಸುತ್ತೆ. ಸೊ ಬಿ ಎಸ್ ಎ ಸೈಕಲ್ ಆಲ್ಮೋಸ್ಟ್ ಎಲ್ಲರೂ ಹತ್ರ ಏನು ಅಂದರೆ ಹೀರೋ ರೇಂಜರು, ಬಿ ಎಸ್ ಎ ಸೈಕಲ್ಲು, ಹೆಣ್ಮಕ್ಳು ಲೇಡಿ ಬರ್ಡ್ ಸೈಕಲ್ ಇರ್ತಿತ್ತು. ಸೊ ಬಿ ಎಸ್ ಎ ಸೈಕಲ್ ಅಂತಲೇ ನಾನು ಸಹ ನೆನ್ಪಿಟ್ಕೊತಾ ಇದ್ದೀನಿ. ಸೊ ನೀವು ಅದನ್ನೇ ಅಂತ. ಇನ್ನೊಂದೇನು ಅಂತಂದರೆ ಈ ವಕೀಲರಿಗೆ ಆಗಲಿ ನ್ಯಾಯಾಧೀಶರಿಗಾಗಲಿ ಹೇಗೆ ಅಂತಂತಂದರೆ ನಮ್ಮ ವಿ ಹ್ಯಾವ್ ಅವರ್ ಓನ್ ಜಾರ್ಗಾನ್ಸ್. ಸ್ವಾಮಿ ಅದು ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ ಅಂತ ಅಷ್ಟೇ ಹೇಳಿ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ. ಅಂದರೆ ಏನಾಗುತ್ತೆ ಅಂದರೆ ಡೈಯಿಂಗ್ ಡಿಕ್ಲರೇಷನ್ ಅಂತ ಅಂದ ಕೂಡಲೇ ಇಮಿಡಿಯೇಟ್ಲಿ ದಿ ನ್ಯಾಯಾಧೀಶರಿಗೆ ಏನಾಗ್ಬಿಡುತ್ತೆ ಅಂದರೆ ಸೆಕ್ಷನ್ 32 ಹೋಗ್ಬಿಡ್ತಾರೆ. ಸೆಕ್ಷನ್ 32 ಹೋದ ಕೂಡಲೇ ಏನಾಗುತ್ತೆ ಅಂದರೆ ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತಹ ಎಲ್ಲ ಪ್ರೊವಿಷನ್ಗಳು, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತಹ ಎಲ್ಲ ಜುಡಿಷಿಯಲ್ ಪ್ರೆಸಿಡೆಂಟ್ಸ್ ಏನಿದೆ ಅದು ನೆನಪಿಗೆ ಬಂದ್ಬಿಡುತ್ತೆ. 3 ಅಥವಾ 4 ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಮುಗಿಸ್ಬಿಡ್ತೀವಿ ನಾವು. ದಟ್ ಈಸ್ ದ ಯೂಶುವಲ್ ಟ್ರೆಂಡ್. ನಾವು ಅಷ್ಟೇ ಏನು ಅಂತಂದರೆ ಹಿಟ್ ಬೈ ಸೆಕ್ಷನ್ 24 ಕನ್ಫೆಷನಲ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಲ್ಲ ಕೊಹರ್ಷನ್ ಅಲ್ಲಿ ಇಂಟಿಮಿಡೇಷನ್ ಇದೆ ಅಂಥದ್ದೇನೋ ಒಂದು ಹೇಳ್ಬಿಟ್ಟು 24 ಕೆಳಗಡೆ ಬಂದ್ಬಿಡತ್ತೆ ಅಂತ ಹೇಳ್ಬಿಡ್ತೀವಿ. ಸೊ ದಿಸ್ ಈಸ್ ಯೂಶುವಲ್ ಟೆಂಡೆನ್ಸಿ. ಆಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಅವ್ರು ಸೆಕ್ಷನ್ 27 ಅಂದ್ಬಿಡ್ತಾರೆ, ಡಿಸ್ಕವರಿ ಆಫ್ ದಿ ಫ್ಯಾಕ್ಟ್ಸ್. ಮೊಬೈಲಲ್ಲಿ ಇಟ್ಟಿದ್ದೀನಿ ನಮಗೆ. ಸೊ ಡಿಸ್ಕವರಿ ಆಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಸೆಕ್ಷನ್ 27 ಅಂತ ಹೇಳ್ಬಿಡ್ತಾರೆ. ಸೊ ಏನಾಗುತ್ತೆ ಅಂತಂದರೆ ಆ ಕಡೆ ಕಕ್ಷಿದಾರನಾಗಲಿ ಅಥವಾ ಜನರಲ್ ಪಬ್ಲಿಕ್ನವ್ರಿಗೆ ಏನಾಗುತ್ತೆ ಅಂತಂದರೆ ಏನಪ್ಪ ಇಷ್ಟೇ ಹೇಳಿ ಮುಗಿಸ್ಬಿಟ್ರಲ್ಲ 3 ನಿಮಿಷದಲ್ಲಿ 4 ನಿಮಿಷದಲ್ಲಿ ಅಂತ ಹೇಳಿ ಅಂತ. ಆ 3 ಅಥವಾ 4 ನಿಮಿಷದಲ್ಲಿ ಒಂದು ನಾವು ನ್ಯೂಮರಿಕಲ್ ನಂಬರ್ ಒಂದು ಸಂಖ್ಯೆ ಹೇಳ್ತೀವಿ. ಎರಡನೇದು ಹೇಳೋದು ಯಾವುದು ಅಂತಂದರೆ ಆ ಪ್ರೊವಿಷನ್ದಿನ ಒಂದು ಹೆಡ್ಡಿಂಗ್ ಹೇಳ್ತೀವಿ. ಅದರಲ್ಲಿ ಅಡಕವಾಗಿರುವಂತಹ ಏನು ಅಂಶ ಇದೆ ಅದನ್ನು ಹೇಳಿಬಿಟ್ಟು ಮುಗಿಸ್ಬಿಡ್ತೀವಿ. ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟಂತಹ ಒಂದು ವಸ್ತುಸ್ಥಿತಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಏನಿದೆ ಅದನ್ನು ಹೇಳಿಬಿಟ್ಟು ಅಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡ್ತೀವಿ. ಸೊ ಈಗ ನಮಗೆ ರಿಯಲ್ ಚಾಲೆಂಜ್ ಏನು ಅಂತಂತಂದರೆ ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮದ್ದು ಏನು ರಿಯಲ್ ಚಾಲೆಂಜ್ ಅಂದರೆ ಸೆಕ್ಷನ್ಸ್ಗಳು ಎಲ್ಲೆಲ್ಲಿದೆ ಅಂತ ಹುಡ್ಕೋದು. ನಾನು ಈ ಭಾರತೀಯ ಸಾಕ್ಷ್ಯ ಅಧಿನಿಯಮನ ಪೊಲೀಸ್ ಆಫೀಸರ್ಸ್ಗಳಿಗೆ ಕ್ಲಾಸ್ ಮಾಡ್ತಾ ಇದ್ದೆ, ಒಂದು ವರ್ಗ. ಯಾಕಂತಂತಂದರೆ ಎಲ್ಲರೂ ಸಹ ಇದಕ್ಕೆ ರೆಡಿ ಆಗಬೇಕು, ಅದಕ್ಕೂ ವರ್ಗ ನಡೀತಾ ಇದೆ. ಅವ್ರ ಪ್ರಶ್ನೆಗಳನ್ನು ಕೇಳೋದು ಹೇಗಿತ್ತು ಅಂತಂದರೆ ಕೋರ್ಟ್ ಎಲ್ಲ ಬದಲಾವಣೆ ಆಗ್ಬಿಡುತ್ತಾ ಸ್ವಾಮಿ, ಏನು ಪ್ರತಿಯೊಂದು ನಾವು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋ ದಾಖಲಾತಿಗಳು ಎಲ್ಲನೂ ಚೇಂಜ್ ಆಗುತ್ತಾ ಅಂತಂದು ನಾನು ಹೇಳಿದೆ ಅವರಿಗೆ, ಸಾಹೇಬರು ಬದಲಾಗಲ್ಲ, ಕೋರ್ಟ್ಗಳು ಬದಲಾಗಲ್ಲ, ನಾವು ಬದಲಾಗಲ್ಲ, ನೀವು ಬದಲಾಗಲ್ಲ, ನಿಮ್ಮ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಎಲ್ಲಿದೆ ಅಲ್ಲೇ ಇರುತ್ತೆ, ಅಕ್ಯೂಸ್ಗಳು ಬದಲಾಗಲ್ಲ. ಸೊ ಪರಿಸ್ಥಿತಿ ಹೀಗಿದೆ. ಆದರೆ ಏನು ಈ ಕಾನೂನಿನ ಮಹತ್ವ ಏನು ಆಗಿತ್ತಂತಂದರೆ ಈ ಕಾನೂನಿಗೆ ಅದರದ್ದೇ ಆದಂತಹ ಮಹತ್ವ ಇದೆ. ಒಂದು ಹೇಳಬೇಕು ಅಂತಂತಂದರೆ ಬಹಳಷ್ಟು ಪ್ರತಿಯೊಂದು ಕಾನೂನಿನ ಒಂದು ಕಮಿಟಿ ರಿಪೋರ್ಟ್ಸ್ಗಳನ್ನು ನೋಡಿದ್ರಿ ಅಂದರೆ BSAದೇ ಆಗಿರ್ಬೋದು, BNA ಆಗಿರ್ಬೋದು, BNNSS ಆಗಿರ್ಬೋದು, ಏನೇ ಆಗಿರ್ಬೋದು, ಅದ್ರ ಕಮಿಟಿ ರಿಪೋರ್ಟ್ ನೋಡಿದ್ರಿ ಅಂತಂತಂದರೆ ಅಲ್ಲಿ ಬಹಳಷ್ಟು ವರ್ಡ್ಗಳನ್ನು ನಮ್ಮ ದೇಶೀಯ ವರ್ಡ್ಗಳಿಗೆ ಕನ್ವರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದು ನಮಗೇನು ಸಂಬಂಧಪಟ್ಟದ್ದಲ್ವೇ ಅಲ್ಲ. ಪ್ಲೀಡರ್ ಆಗಲಿ, ಅಡ್ವೊಕೇಟ್ ಆಗಲಿ, ಇಂಡಿಯಾ ಆಗಲಿ, ಭಾರತೀಯ ಆಗಲಿ ನಾವು ಕೆಲಸ ಮಾಡಲೇಬೇಕು. ನಾವು ಕಕ್ಷಿಗಾರರ ಪರವಾಗಿ ನಾನು ವಾದ ಮಂಡಿಸಲೇಬೇಕು, ನೀವು ನಿಮ್ಮ ತೀರ್ಮಾನನ ಕೊಡಲೇಬೇಕು, ತೀರ್ಪನ್ನ ಕೊಡಲೇಬೇಕು. ಸೊ ಅಲ್ಲಿ ಒಂದಿಷ್ಟು ಆಬ್ಜೆಕ್ಷನ್ಗಳನ್ನು ರೈಸ್ ಮಾಡಿದರು. ಏನು ಅಂತಂದರೆ ಈ ರೀತಿಯಾದಂತಹ ದೇಸಿ ವರ್ಡ್ಗಳನ್ನು ಉಪಯೋಗಿಸೋದು ಅಂದರೆ ಯಾವುದು ಹಿಂದಿ ವರ್ಡ್ಗಳಾಗಲಿ ಈ ರೀತಿ ಉಪಯೋಗಿಸೋದು ತರವಲ್ಲ, ಸೂಕ್ತ ಅಲ್ಲ ಅಂಥೇಳಿ. ದೆನ್ that particular objection, when it was raised, it has been rejected, giving reference to Article 248. So ultimately it is the Constitution which is binding on us. We have to work under the aegis of the Constitution. So I don't want to concentrate anything on those things, that is deletion, the deletion of those words, replacement of those words, that is various terminology, ಕಲ್ಕತ್ತಾ ಇದ್ದಿದ್ದು ಕೋಲ್ಕತ್ತಾ ಆಗಿದ್ದು ಅವೆಲ್ಲನೂ ಸಹ ನಾನು ಕಾನ್ಸಂಟ್ರೇಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಇಲಿಸ್ಟ್ರೇಷನಲ್ಲಿ. ನನಗೆ ಕೊಟ್ಟಿರುವಂತಹ ಒಂದು ಏನು ಸಬ್ಜೆಕ್ಟ್ ಇದೆ ದಟ್ ಈಸ್ ಎಡಿಷನ್, ಡಿಲಿಷನ್, ಮೋಡಿಫಿಕೇಶನ್, ರಿಆರ್ಗನೈಸೇಷನ್. ಸೊ ಇದನ್ನು ಸ್ಟ್ರಕ್ಚರಲಿ ಹೇಗೆ ಚೇಂಜ್ ಮಾಡಿದ್ದಾರೆ ಅಂಥೇಳಿ ಮೊದಲನೇ ಒಂದು ಭಾಗದಲ್ಲಿ ಆದಷ್ಟು ಕಂಟೆಂಟ್ಸಿನ ಹೇಳೋಕೆ ನಾನು ಇಷ್ಟಪಡಲ್ಲ. ದ ರೀಸನ್ ಈಸ್ ದ್ಯಾಟ್ ಯು ಆಲ್ ಆರ್ ಜುಡಿಷಿಯಲಿ ಟ್ರೈನ್ಡ್, ಯು have been dealing with these provisions day and out. You are already aware of the contents. When you are already aware of the contents, again I am harping more on those words or phrases or the contents of the section. it will not serve any purpose. So structurally how it has been changed, I will try to concentrate on that, then I will try to explain. First of all, this particular legislation is coming into effect. This particular legislation, the BSA is coming into effect on 1st July 2024. ಇವತ್ತಿಗೆ ಅಂದರೆ 1/7/2024ಕ್ಕೆ 152 ವರ್ಷದ ಹಿಂದೆ, ಸರಿಯಾಗಿ 152 ವರ್ಷದ ಹಿಂದೆ ಇಂಡಿಯನ್ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ ಬಂದಿತ್ತು. ಸೊ 1872ರದ ಲೆಜಿಸ್ಲೇಷನ್ ಏನಿದೆಯಲ್ಲ, that particular legislation draft was prepared in the year 1871 and it was legislated in the 1872. It had come into effect on 1872. ಸೊ 152 ವರ್ಷದ ಹಿಂದೆ ಈಗ ಕಾನೂನಲ್ಲಿ ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಬದಲಾವಣೆ ಇಲ್ಲ. ದ ಫಂಡಮೆಂಟಲ್ಸ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ ಕೆನಾಟ್ ಬಿ ಚೇಂಜ್. ದ ಫಂಡಮೆಂಟಲ್ಸ್ ಆಫ್ ಎಸೆನ್ಷಿಯಲ್ ಪಾರ್ಟ್ ಅನ್ನೋದಲ್ಲ, ಫಂಡಮೆಂಟಲ್ಸ್ ಆಫ್ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ ಕೆನಾಟ್ ಬಿ ಚೇಂಜ್ಡ್. ಸೊ those aspects have been retained, reiterated, further declared in the new act also. But what is the change? In my second part of my lecture series, I am going to explain what is the change. There is also marked change. There is a marked change in the provisions of the Indian Evidence Act. First of all, definition of evidence. The second substantial change is the definition of documents. So ಸಾಕ್ಷಿಯ ವ್ಯಾಖ್ಯಾನ ಸ್ವಲ್ಪ ಬದಲಾವಣೆ ಆಗಿದೆ. ಎರಡನೇದು ದಸ್ತಾವೇಜಿನ ವ್ಯಾಖ್ಯಾನ ಬದಲಾವಣೆ ಆಗಿದೆ. ಸಾಕ್ಷಿಯ ವ್ಯಾಖ್ಯಾನ ಮೊದಲು ಬದಲಾವಣೆ ಆಗಿರಲಿಲ್ವಾ ಈ ಪ್ರಶ್ನೆ ಕೇಳಿದ್ರಿ ಅಂತಂತಂದರೆ ಏನಂದರೆ ನನ್ನ ಉತ್ತರ ಏನು ಅಂತಂದರೆ 2000ರಲ್ಲಿ ಎಲ್ಲ ನಾವು ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ಮೈ ಕಲೀಗ್ ವಿಜಯ್, ಆಲ್ ಆಫ್ ಅಸ್ ವಿ ಸ್ಟಾರ್ಟೆಡ್ ಅವರ್ ಪ್ರಾಕ್ಟೀಸ್ ಡ್ಯೂರಿಂಗ್ ದ ಇಯರ್ 2000. When we started our practice 2000, he was a colleague of the great A.N. Jairam and additional Solicitor General, as well as he was a former Advocate General. So when we started practice in the year 2000, all of us, most of the advocates who had passed in the year 1992, 93 or subsequently, they had a email ID. That same email ID or the modified version of the email ID we have. In the year 2000, when we started practice, we used to inform the senior that we are going to send the email to your home. You please download and correct it. That was the trend. That was the approach. Then the senior, ಹೌದು ಆ ರೀತಿ ಕಳ್ಸೋಕ್ಕಾಗತ್ತಾ ಅಂತ ಪ್ರಶ್ನೆ ಕೇಳ್ತಿದ್ರು. ಸೊ ಇಲ್ಲ ಸರ್, ನೀವು ಮನೆಗೆ ಹೋಗಿ, ನೀವು ಚಿಂತೆ ಮಾಡಬೇಡಿ, 7:30-8 ಗಂಟೆಗೆ ನಿಮಗೆ ಇರುತ್ತೆ ಅಂತ ಹೇಳಿ ಅಂತ. ಅಲ್ಲೊಂದು ಪ್ರಿಂಟೌಟ್ ನಿಮ್ಮ ಮನೆಯಲ್ಲಿ ಯಾರಾದರೂ ಹೆಲ್ಪ್ ತೊಗೊಂಡ್ಬಿಟ್ಟು ಪ್ರಿಂಟೌಟ್ ತೊಗೊಳ್ಳಿ, ಕರೆಕ್ಷನ್ ಮಾಡಿ, ಫೋಟೋ ಅಂತೂ ಸಾಧ್ಯ ಇರಲಿಲ್ಲ. ಆ ಕರೆಕ್ಷನ್ ಬೆಳಿಗ್ಗೆ ತಂದು ಕೊಡಿ, ಅಥವಾ ನಾವು ಯಾರಾದರೂ ಬಂದು ತೊಗೊಂಡು ಹೋಗ್ತೀವಿ ಅಂತ ಹೇಳಿ. ಸೊ ಆ ರೀತಿ ಪರಿಸ್ಥಿತಿ ಇತ್ತು. ಅವಾಗ ಇನ್ಫಾರ್ಮೇಷನ್ ಟೆಕ್ನಾಲಜಿ ಆ್ಯಕ್ಟ್ ಬಂದಿತ್ತು. ಅವಾಗ ಇನ್ಫಾರ್ಮೇಷನ್ ಟೆಕ್ನಾಲಜಿ ಆ್ಯಕ್ಟ್ ಬಂದಾಗ ಬಹಳಷ್ಟು ಜನ ಏನಂದರೆ ಇದೇನಿಲ್ಲ, ನಮಗೇನು ಉಪಯೋಗ ಇಲ್ಲ, ಇಂಜಿನಿಯರ್ಸ್ಗಳಿಗೂ ಮಾತ್ರ ಉಪಯೋಗ ಅಂತ ಹೇಳಿದರು. ಬಹುಶಃ ನೀವೆಲ್ಲ ಒಪ್ಬೋದು ಈ ಪ್ರಶ್ನೆ. ನಾನು ಹೇಳ್ತಾ ಇರುವಂತಹ ಒಂದು ಏನು ನಾನು ಹೇಳೋ ರೀತಿ ಇದೆ, ನಾನು ಏನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ ನೀವೆಲ್ಲ ಒಪ್ಬೋದು. ಬಟ್ 2003-2004ರಲ್ಲಿ ಸಂಪೂರ್ಣವಾದಂಥ ಬದಲಾವಣೆ ಆಯಿತು. ಇಮೇಲು, ನಾವು RTC ತಗೊಳ್ಳೋ ಕಾಪಿಗಳು, RTCಗಳನ್ನು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋ ರೀತಿ, ಯಾಕಂತಂದರೆ RTC ಫಿಸಿಕಲ್ RTC ಹೋಗ್ಬಿಡ್ತು. ಕೋರ್ಟ್ ಮುಂದೆ ಹಾಕೋದು, ನಾವು ಫಿಸಿಕಲ್ RTCಗಳನ್ನು ಹಾಕೋದು ಬಿಟ್ಬಿಟ್ವಿ. ಹಾಕೋದು ಯಾವುದು ಅಂತಂದರೆ ಇಲೆಕ್ಟ್ರಾನಿಕ್. ಅದೊಂದು ಸ್ಟಿಕ್ಕರ್ ಬರ್ತಿತ್ತು, ಅದ್ರ ಮೇಲೆ ಪ್ರೆಸ್ ಮಾಡಿಬಿಟ್ಟು ತಹಸೀಲ್ದಾರ್ ಸಿಗ್ನೇಚರ್ ಮಾಡ್ತಿದ್ದ, ಅದನ್ನೇ ಹಾಕೋದು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ತೀವಿ. ಸೊ ವಿ ಸ್ಟಾರ್ಟೆಡ್ ಅಡಾಪ್ಟಿಂಗ್ this electronic evidence. Then unknowingly, subconsciously, also we started following Information Technology Act as well as the Indian Evidence Act with reference to electronic records. Then we started appreciating those records. Then we being advocates started producing it, and those documents were marked also. So appreciation start ಆಯಿತು. ಆವಾಗ ಜಜ್ಮೆಂಟ್ಗಳೆಲ್ಲ ಬಂತು. ಒಂದು ಅನ್ವರ್ ಬಂದರು, ಆಮೇಲೆ ಶಫಿ ಬಂತು, ಟೊಸ್ಮೋ ಬಂತು. ಟೊಸ್ಮೋ ಆದಮೇಲೆ ಈಗ ಗಜಾನನ್ ರಾವ್ ಲಾಸ್ಟ್ ಜಜ್ಮೆಂಟ್ ಏನಿದೆ ಈಗ ರೆಫರೆನ್ಸಿಗಿದೆ, ಇವೆಲ್ಲ ಜಜ್ಮೆಂಟ್ಗಳು ಬಂತು. ಬಂದ ಕೂಡಲೇ ಯಾವುದದು ಡೆಲ್ಲಿ ಕೇಸ್ನಲ್ಲಿ ಟೆರರಿಸ್ಟ್ ಅಟ್ಯಾಕಿಗೆ ಸಂಬಂಧಪಟ್ಟಂಥದ್ದು, ಕಾಲ್ ಡೀಟೇಲ್ಸ್ ರೆಕಾರ್ಡ್, CDR ಹೇಗೆ ಇದನ್ನು ಮಾಡಬೇಕು, ಏನು, ಇವೆಲ್ಲ ಜಿಜ್ಞಾಸೆಗಳು ಪ್ರಾರಂಭ ಆಯಿತು. ಅದಾದಮೇಲೆ ಏನಾಯಿತು ಅಂತಂದರೆ ಈ ಇಲೆಕ್ಟ್ರಾನಿಕ್ ಎವಿಡೆನ್ಸಿಗೆ ಅದರದ್ದೇ ಆದಂತಹ ಮಹತ್ವ ಇದೆ ಅನ್ನೋದನ್ನು ನಾವು ಅರ್ಥ ಮಾಡ್ಕೊಳ್ಳೋಕೆ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ವಿ. ಆವಾಗ ಪ್ರಶ್ನೆ ಬಂತು, ಹೌ ಮೆನಿ ಟೈಪ್ಸ್ ಆಫ್ ಎವಿಡೆನ್ಸ್? The question was posed to ourselves, how many types of evidence? There are only two types of evidence. One is oral evidence, another one is electronic evidence, documentary evidence. Now the question was, this particular electronic evidence fall under what category? It fall under the documentary evidence. There was a discussion, there was a deliberation, it falls under a different category, it is a third form of evidence. So that particular discussion continued till the legislation of this particular BSA. And this particular BSA answered this question, and first time this particular BSA says that the electronic evidence is also a documentary evidence. The reason is that evidence, definition of evidence was amended in the year 2000. Then the definition, the electronic record was included as an evidence. But the status of documentary evidence was not given when the amendment was made in the year 2000. Information Technology Act introduced madidru. In tandem with the Information Technology Act, Evidence Act was also amended. When the Evidence Act was amended, only the definition of evidence was amended to include the electronic record, whereas the definition of document was not amended. So the status of electronic record has been elevated to the status of document first time in the year 2024, or in this particular legislation BSA 2023. So this is the marked difference. This particular difference or marked difference will assist the court in administration of justice. ಯಾಕಂದರೆ ಪ್ರತಿಯೊಂದು ಸಹ ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್ ನಾನು ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿಗೆ ಬರಬೇಕು ಅಂತಂದರೆ ನನ್ನ ಮನೆಯಿಂದ ನಾನು ಏನು ಮಾಡ್ತೀನಿ ಅಂತಂದರೆ, ಒಂದು ಮೊಬೈಲ್ನಲ್ಲಿ ಇಲ್ಲಾಂದರೆ ನನ್ನ ಕಾರ್ನಲ್ಲಿ ಕರ್ನಾಟಕ ಜುಡಿಷಿಯಲ್ ಅಕಾಡೆಮಿ ಅಂತ ಬರಿತೀನಿ, ಡೈರೆಕ್ಷನ್ ಕೊಡ್ತಾ ಇರುತ್ತೆ, ಅದ್ರ ಪ್ರಕಾರ ಬರ್ತೀನಿ. ನಾನು ಬಂದ ಕೂಡಲೇ ಏನಾಗುತ್ತೆ, ನಾನು ಗೂಗಲ್ನಲ್ಲಿ ಫುಟ್ ಪ್ರಿಂಟ್ನಲ್ಲಿ ನಾನು ಎಲ್ಲಿ ಹೋಗಿದ್ದೆ ಅಂತ ಅನ್ನೋದು ಸಿಗುತ್ತೆ. ಏನು ಫುಟ್ ಪ್ರಿಂಟ್, ಡಿಜಿಟಲ್ ಫುಟ್ ಪ್ರಿಂಟ್ ಇದೆಯಲ್ಲ, ನಾನು ಎವಿಡೆನ್ಸ್ ಬಿಡ್ತಾ ಹೋಗ್ತಾ ಇದ್ದೀನಿ, ನನ್ನ ಮನೆಯಿಂದ ಎವಿಡೆನ್ಸ್ ಬಿಡ್ತಾ ಹೋಗ್ತಾ ಇದ್ದೀನಿ. ನನ್ನ ಹೆಂಡತಿ ಏನಾದರೂ ನನ್ನನ್ನು ಟ್ರೇಸ್ ಮಾಡ್ಬೋದು ಅಂತಂದರೆ, ಒಂದು ನನ್ನ ಕಾರಿಗೆ ಹೋಗ್ಬಿಟ್ಟು ಚೆಕ್ ಮಾಡ್ಬೋದು ಇವನು ಎಲ್ಲೆಲ್ಲಿ ಹೋಗಿದ್ದಾನೆ ಅಂತೇಳಿ. ಶಿ ಕ್ಯಾನ್ ರಿಟ್ರೀವ್ ಇಟ್ ಆ್ಯಂಡ್ ಶಿ ಕ್ಯಾನ್ ಕಲೆಕ್ಟ್ ಆಲ್ ದ ಇನ್ಫಾರ್ಮೇಷನ್ ವೇರ್ ಆಲ್ ಐ ಹ್ಯಾವ್ ರೋಮ್ ಟುಡೇ ಇನ್ ಬೆಂಗಳೂರು. ದಟ್ ಈಸ್ ಅ ಡಿಜಿಟಲ್ ಎವಿಡೆನ್ಸ್. It is not an electronic evidence. I will explain what is the difference between electronic record and digital record, but it is an evidence. The digital footprint, what I have left before reaching this particular premises, all are electronic evidence, and that particular evidence has attained the status of a documentary evidence. So this is the marked difference. This is going to help us in administration of justice. But there are many challenges, and those challenges are required to be considered, we are required to sensitize with those challenges. We need to change our approach in determination of the cases, adjudication of the cases, because these challenges are not so simple. ನಾನು ಎಕ್ಸಾಂಪಲ್ಗಳನ್ನು ಕೊಡಲಿಲ್ಲ ಅಂದರೆ ನಡೆಯಲ್ಲ. ಈಗಿದ್ದಂತಹ ಪೆನ್ ಡ್ರೈವ್ ಕೇಸ್ ಆಗಿರ್ಬೋದು, ಪೆನ್ ಡ್ರೈವ್ ಅಂತ ಹೇಳಿದ್ದು ತಪ್ಪು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಅಂದರೆ ಆ ರೀತಿ ಹೇಳಬೇಡಿ ಅಂತ ಹೇಳಿ ಅಂತ ಯೋಚನೆ ಮಾಡ್ಬೋದು. ಯಾಕೆ ಅಂದರೆ ಒಂದು ಪೆನ್ ಡ್ರೈವ್ ಕೊಟ್ಟರು ಸಹ ಮೊದಲೇನು ಅಂತಂತಂದರೆ ಇಂಟಿಗ್ರಿಟಿ ವಾಸ್ ನಾಟ್ ಸೋ ಮಚ್ ಚಾಲೆಂಜ್ಡ್. Integrity was not the issue, because blindly used to consider digital evidence is a very good piece of evidence. It is a best piece of evidence. Now, the integrity of that particular that particular electronic record is a real challenge. With this preface, I will start with my next version. It is with respect of the structure of the evidence. So, there are in the earlier Indian Evidence Act, 167 sections were there. 170 section ಏನಿದೆಯಲ್ಲ, ಮಾಡ್ರೇಟ್ ಇನ್ಕ್ರೀಸ್ ಇದೆ. ಅದೇನು ಬಹಳಷ್ಟು ಏನು ಬಂದಿಲ್ಲ, ಅದು ಯಾವ್ದು ಏನು. ನೆಕ್ಸ್ಟ್ ಈ ಕಾನ್ಸೆಪ್ಟಲ್ಲೇನೆ ಈ ಒಂದು ಹೊಸ ಲೆಜಿಸ್ಲೇಷನ್ ತರೋದಕ್ಕೆ ಉದ್ದೇಶದಲ್ಲೇ ಹೇಳಿದ್ದಾರೆ. ಏನು ಅಂತಂದರೆ ಟೆಕ್ನಾಲಜಿಕಲ್ ಅಡ್ವಾನ್ಸ್ಮೆಂಟ್ ಈಸ್ ದ ರೀಸನ್ ಫಾರ್ ದಿಸ್ ಲೆಜಿಸ್ಲೇಷನ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಸೊ ವಿ ನೀಡ್ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ವಾಟ್ ಈಸ್ ದ ಟೆಕ್ನಾಲಜಿಕಲ್ ಅಡ್ವಾನ್ಸ್ಮೆಂಟ್ ಇನ್ ದ ಪಾಸ್ಟ್. So that is the particular legislation legislated. First of all, earlier Indian Evidence Act had 3 parts, that is part 1, part 2, part 3. Those 3 parts have been further divided into the part. Slightly there is a structural change. Part 1 was having section 1 to 55. ಕ್ವಿಕ್ಕಾಗಿ ಮುಗಿಸಿದ್ವಿ ಅಂತ ಸ್ಟ್ರಕ್ಚರ್ ಏನು ಅಂತ ತಿಳ್ಕೊಂಡ್ಬಿಟ್ವಿ ಅಂತಂದ್ರೆ ಈ ಸೆಕ್ಷನ್ 6 ಸೆಕ್ಷನ್ 4 ಆಗುತ್ತೆ. ನೆಕ್ಸ್ಟ್ ಏನು ಅಂತಂದ್ರೆ ಸೆಕ್ಷನ್ 32 ಏನಿದೆಯಲ್ಲ ನಮ್ಮ ಟೈಮ್ ಡಿಕ್ಲರೇಷನ್, ಸೆಕ್ಷನ್ 26 ಆಗುತ್ತೆ. ಸೆಕ್ಷನ್ 27 ಏನಿದೆಯಲ್ಲ ನಮ್ಮ ಕನ್ಫೆಷನ್ ರಿಲೇಟೆಡ್, ಅದೇನಾಗುತ್ತೆ ಸೆಕ್ಷನ್ 23. ಸೊ ಅದನ್ನ ಒಂದ್ಸತಿ ನಾವು ತಿಳ್ಕೊಂಡ್ಬಿಟ್ರಿ ಅಂತಂದ್ರೆ ಅದನ್ನ ಎಕ್ಸ್ಪ್ಲೈನ್ ಮಾಡೋ ಪ್ರಯತ್ನ ಮಾಡ್ತೀನಿ. ದೆನ್ ವಿ ವಿಲ್ ಕಮ್ ಬ್ಯಾಕ್ ಟು ದಿ ಕಂಟೆಂಟ್ಸ್. So relevancy of facts, earlier part was section 155. That was well, that is part 1. That was dissected into 2 parts. That is so this is the one substantial change. That is that was section 56 to 100. On notice, then document, then the oral evidence, documentary evidence, then presumptions, which fall under this particular chapter number, part T. The sections are 51 to 103. There is no much difference. Then part 3 has been retained as it is. That will not change. Part 3 has been retained. The sections are 101 to 167. That is burden of proof, estoppel, production, effect, all those things. That has come into the same part, but different number. That is production and effect of evidence. Last sections 170. Legislation was a first all India legislation. First legislation which was legislation when there is a repeal effect of that has been section 170. A separate chapter has been provided. Here, first part, that is chapter number 1. Earlier it was under the caption of preliminary. This particular earlier chapter was having 4 sections. ಒಟ್ಟಾರೆ 4 ಸೆಕ್ಷನ್ಗಳಿತ್ತು. ಆ 4 ಸೆಕ್ಷನ್ ಮೊದಲನೇ ಸೆಕ್ಷನ್ 1 ಏನಿದೆಯಲ್ಲ ಮಾಡುವ ಅವಶ್ಯಕತೆ ಇಲ್ಲ. Probably in the year 1932, for that reason that particular section was redundant. For that reason that section 2 has been discontinued. For that reason ನಮಗೇನಾಯ್ತು, ಪಾರ್ಟ್ ಚಾಪ್ಟರ್ 1 ನಲ್ಲಿ ಒಟ್ಟಾರೆ 4 ಸೆಕ್ಷನ್ ಇತ್ತು, ಒಂದು ಕಡಿತಗೊಳ್ಳು ಏನಾಯ್ತು, 3 ಸೆಕ್ಷನ್ ಮಾತ್ರ ಉಳಿತು. 3ನೇ ಸೆಕ್ಷನ್ ಓಲ್ಡ್ ಸೆಕ್ಷನ್ ನಲ್ಲಿ old Indian Evidence Act, section 3 was an definition clause, but it was not a definition clause, it was an interpretation. Only change, there is no material change. So now it has become definitions. So since that particular section has no much difference. So may presumption ನಾವು ಜುಡಿಷಿಯಲ್ ಎಕ್ಸಾಮ್ ನೋಟ್ಸ್ಗಳನ್ನು ಬರೀಬೇಕಾದ್ರೆ ಏನು ಅಂತಂದ್ರೆ ಅದ್ರ ಮೇಲೆ ಪ್ರಶ್ನೆ ಗ್ಯಾರಂಟಿ ಅದು. ಸೊ ಏನಾಗ್ತಿತ್ತು ಅಂತಂದ್ರೆ ಕ್ಲಾಸ್ನಲ್ಲಿ ಏನಾಗ್ಬೇಡಿ ಸೆಕ್ಷನ್ಗೆ ಕನೆಕ್ಟ್ ಮಾಡಿ. ಸೊ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಸೆಕ್ಷನ್ 4 ಏನಿದೆಯಲ್ಲ ನಾವು ಮರ್ತ್ಬಿಡ್ಬೇಕಾಗತ್ತೆ. ನೆಕ್ಸ್ಟ್, when 2000 amendment was given effect to Indian Evidence Act because of the Information Technology Act, then there was a one particular explanation was given. Next, an explanation was given in reference to Information Technology Act. Electronic signature certificate. So many terms defined in the Information Technology Act. The same thing has been retained in section 1. Shall have the same. So legislator has adopted IPC definition available in the IPC as well as CRPC, more particularly Information Technology in the Evidence Act. So what are the definition which is available? The definition which are available in the Indian Penal Code or the various terms and the terms which are available in those legislation, by adoption those terms have to be followed and has to be read in this particular Indian Evidence Act. So it has become now part. There is a legislature has adopted those terms and it has become a part of this particular definition. So this particular this is a change that you need to follow it, and this is the then I was referring to the amendment of definition of document and evidence. I will try to consider that particular portion at the later part. Then the next chapter number 2. That was earlier. Easy ಇರ್ತಿತ್ತು. ರೆಸ್ ಗೆಸ್ಟ್ ಅಂದ್ಕೂಳೆ ಸೆಕ್ಷನ್ 6 ಅಂತಿದ್ವಿ. ಅದಾದ್ಮೇಲೆ ಏನು ಅಂತಂದ್ರೆ ಸೆಕ್ಷನ್ 6 the same part has been included. Same part followed. That particular part is section 3 to 14. However, there is one mark difference. Section 5 says that what are the facts are relevant facts. No problem. ಇದನ್ನು ತೆಗೆದುಬಿಟ್ಟು ಇದೊಂದು ಸ್ವಲ್ಪ ಇದನ್ನು ತೆಗೆದುಬಿಟ್ರಿ ಪ್ಲೀಸ್. So what are the facts are relevant facts? So the section 5 declares that all the facts which are enumerated in section 6 to 55 are the relevant facts. That is the gist of that particular section 5. That has been reiterated in section 3. That is immediately after the chapter that is relevancy of facts. That is what has been included. The remaining portion, that is section 4 to 14. Section 4 to 14 are the other facts with a heading. That particular heading is that closely connected facts. This particular heading was not earlier available in the index of the Indian Evidence Act. Please try to understand. Section 5 to 14. Section 5 to 14 are considered, section 4 to 14 are considered under the heading of closely connected facts. This closely connected fact subheading chapter was not earlier available. This is a marked difference. Then there is, otherwise there is no difference. In earlier part, there were 7 subchapters. Earlier part, there were 7 subchapters. Now there are 8 subchapters. Please, I just want to explain. Those 7 subchapters are unnumbered subchapters. So the 8 subchapters which have been included, they are also unnumbered. Among the 8 subchapters, the first chapter is closely connected facts. Next one. So in this particular category, that is earlier, that is section 5 to 16, there were 11 concepts. Those same 11 concepts have been included in the 11 sections. There is no change. There is no material change. So legislator rightly provided new heading for section 4 to 14. Earlier there was no separate heading for that. The legislator had thought that it is necessary to give a separate heading. So he has rightly given a separate heading, closely connected, under the head of the closely connected file. So this particular portion, when we are examining this particular portion, you need to understand that section 2 of the earlier act has been completely obliterated because it was a repealing. It had become redundant. And then the section 4, may presume, shall presume, conclusive proof, has merged with the definition clause. That is the new section, that is section 2. So whenever section 6, 7, 8 ರೆಸ್ಗೆಸ್ಟೇ ಆದಮೇಲೆ ನಾವು ಏನು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾ ಇದ್ವಿಲ್ಲ ಸೆಕ್ಷನ್ 16, ಅದಕ್ಕೆ 2 ನಂಬರ್ ಒಂದು ಕಳಿತಗೊಳಿಸಿದ್ವಿ ಅಂತಂದರೆ ನಮಗೆ ಹಳೆ ಪ್ರೊವಿಷನ್ನೇ ಸಿಗುತ್ತೆ. ಸೊ ರೆಸ್ಗೆಸ್ಟೇ ಎಲ್ಲಿ ಬರುತ್ತಪ್ಪ ಅಂತಂದರೆ ಸೆಕ್ಷನ್ 6 ಅಲ್ಲಿ ಬರಲ್ಲ, ಹೊಸ BSAದಲ್ಲಿ ಎಲ್ಲಿ ಬರುತ್ತೆ, ಸೆಕ್ಷನ್ 4 ಬರುತ್ತೆ. ಅಷ್ಟೇ ವ್ಯತ್ಯಾಸ, ಅದು ಬಿಟ್ಟರೆ ಬೇರೆ ಏನೂ ಇಲ್ಲ. ಸೊ ಒಂದು ವೇಳೆ ನಾನು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕಾದ್ರೆ ಸ್ವಾಮಿ ರೆಸ್ಗೆಸ್ಟೇ ಸೆಕ್ಷನ್ 6 ಅನ್ನೋ ಹಾಗಿಲ್ಲ, ಇನ್ಮೇಲಿಂದ ಸ್ವಾಮಿ ರೆಸ್ಗೆಸ್ಟೇ ಸೆಕ್ಷನ್ 4 ಅಂತ ನಾನು ಹೇಳಬೇಕಾಗುತ್ತೆ. ಸೊ ದಿಸ್ ಈಸ್ ದ ಚೇಂಜ್, ದಿಸ್ ಈಸ್ ದ ಓನ್ಲಿ ಮಟೀರಿಯಲ್ ಚೇಂಜ್ ಇನ್ ದಿ ನ್ಯೂಮರಿಕ್ಸ್. ಸಂಖ್ಯೆಯಲ್ಲಿ ಮಾತ್ರ ಬದಲಾವಣೆ ಆಗಿದೆ ಈ ಚಾಪ್ಟರ್ನಲ್ಲಿ. ಅದಕ್ಕಿಂತ ಬೇರೆ ಯಾವುದೇ ರೀತಿಯಾದಂಥ ಮಹತ್ತರವಾದಂತಹ ಬದಲಾವಣೆ ಏನೂ ಆಗಿಲ್ಲ. ಯಾಕಂದರೆ ನಾನು ಇದನ್ನು ಹೇಳಲೇಬೇಕಾಗತ್ತೆ, ನಿಮಗೆ ಸ್ಟ್ರಕ್ಚರಲಿ ಚೇಂಜ್ ಆಗಿರೋದು ಹೇಳಿದ್ರಿ ಅಂತಂದರೆ ಮುಂದೆ ಅನುಕೂಲ ಆಗುತ್ತೆ ಅಂತ. ನೆಕ್ಸ್ಟ್, ದ ನೆಕ್ಸ್ಟ್ ಪಾರ್ಟ್ ಆರ್ ನೆಕ್ಸ್ಟ್ ಸಬ್ ಚಾಪ್ಟರ್ among the 7 chapters, among the 8 chapters, the second chapter in the new legislation, first chapter in the old legislation, is admissions. In earlier it was section 17 to 31 dealing with the admissions as well as confessions. Dealing with the admission as well as confession. That particular section, that particular provision has been renumbered as section 15 to 25. Now it has been renumbered as 15 to 25. That particular provision also deals with the admissions and confession only. Now earlier section 17 to 23 and 31 were dealing with admissions. 17 adadmele forms of admissions. Then last one, the effect of admission, we used to find in section 31. Now the same provision are available from section 15 to 21 and 25. So the confession enittala, we used to find it in old legislation from section 24 to 30. Now it is available in 22 to 24. Please try to understand. The 24 to 30, 24, 25, 26, 27, 28, 29, 30. Total how many sections? 7 sections. These 7 sections have been merged and it has been incorporated in only 3 sections, that is 22 to 24. Entire concept of confession has been now merged in 3 sections, that is 22 to 24. ನಾವೆಲ್ಲ ನೆಕ್ಸ್ಟ್ ನಿಮ್ಮ ಕ್ಲಾಸ್ ಇದೆಯಲ್ಲ ಸೋಮಶೇಖರ್ ಸಾಹೇಬ್ರದ್ದು, ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ರು ಏನು ಅಂತಂತಂದರೆ ಸೆಕ್ಷನ್ 24 to 30 ಏನಿದೆಯಲ್ಲ, ಸಗ್ರಿಗೇಟ್ ಆಗಿ ಒಂದೊಂದೇ ಸೆಕ್ಷನ್ ಆಗಿ ಓದಕ್ಕೆ ಹೋಗಬೇಡಿ. ಪ್ಲೀಸ್ ಟ್ರೈ ಟು ರೀಡ್ ದ ಸೆಕ್ಷನ್ 24 to 30 ಟುಗೆದರ್. ಒಂದಾದ್ಮೇಲೆ ಒಂದು ಓದೋಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಿ. ದೆನ್ ಯು ವಿಲ್ ಗೆಟ್ ಆನ್ ಐಡಿಯಾ, ದೆನ್ ಯು ವಿಲ್ ಗೆಟ್ ಆನ್ ಅಪ್ರೋಚ್ ಆಫ್ ದಿಸ್ ಕನ್ಫೆಷನ್ ಅಂತ ಹೇಳಿ. ಸೊ ದಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಡನ್ ಬೈ ದ ಲೆಜಿಸ್ಲೇಚರ್. ಇಟ್ ಈಸ್ ಎ ಕಮೆಂಡಬಲ್ ವರ್ಕ್ ಬಿಕಾಸ್ ಇಟ್ ಈಸ್ ವೆರಿ ಈಸಿ ಟು ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. So that has been merged in 3 sections, that is 22 to 24. Now, the 22 of the old act, the 22A of the old act that was with respect of the admissions. I'm just again falling back to the admission. 22A of the old act was with respect of oral admission as to the contents of the electronic record. When there was an amendment to the Indian Evidence Act, this oral admission, if it is in the form of an electronic record, how it has to be, whether it is relevant or not, was the question. For that reason, this particular section 22A was incorporated, because 22A and 22, one are the same. The 22 speaks about oral admission in documents. 22A used to deal with oral admission in electronic records. Those two has been submerged. Those two has been merged, and the product is section 20. Section 20, subsection 1 deals with oral admission in documentary evidence. Section 20, subsection 2 deals with oral admission in electronic evidence. Now, this particular change is a substantial change. The reason is that when we go to the definition of document, when the document has been defined, there the electronic record has been elevated to the position of documents. So here, that has been given effect to here. So earlier, what was considered as a documentary evidence, oral admission in the documentary evidence, the same status has been given to the electronic record, and that is the reason why it has merged in section 22. That is, new avatar is section 20. Okay, next Hogi. Okay, now there is one material change with respect of confession. Of course, the contents I'm trying to avoid it. The coercion has been included. The coercion has been included in the new section 22, which was earlier 24. Inducement, threat, then promise. In addition to that, now the coercion has been incorporated. Now, if it is a product of the confessional statement, if it is a product of coercion, then it will become an irrelevant. Earlier, it was by way of a judicial pronouncement, the coercion was also considered as one of the component. But now it has got a legislative recognition also. Next. So, if we take this particular chapter, that is admission chapter, which deals with the admission and confession, earlier there were 7 sections, the confessional. Earlier there were 7 sections. Now it has been reduced to 3 sections. That is the mark change. But all the contents of those 7 sections have been retained as it is, and it has been incorporated in these sections, 3 sections. Then section 24, 28, 29 of the old act, which used to deal with relevancy and irrelevancy of confession statement, that is 24, 28, 29. That is, entire provision is available in one section, that is section 22. So 24, 28, 29, now it is available in 22. Whereas section 25 to 27, that is the confessional statement made to a police officer, that particular provision is available in one section. That is section 23. So now I am not supposed to mention section 27. I am supposed to mention 23 when I am arguing before you all. Next one is, there is a deeming provision which has been effected to, that is section 24, with respect of joint trial. And this particular deeming provision has been incorporated if a particular person is absconding, if that particular confessional statement can be considered against that particular absconding person, or if that particular person is declared as a proclaimed offender, proclamation has been issued under the new CRPC. So that particular provision has been incorporated in this particular section. That is the only mark difference, and there is a reference to the section 84 of the new CRPC. Next. Now here, the next what we come here is, admission is over, the confession is over. The earlier one is section 17 to 31. After section 17 to 31, we used to go to the dying declaration, that is section 32. Now, that particular section 17 has been renumbered. It is up to section 25. It has been renumbered and it is up to section 25. Immediately after section 25, the next section is section 26. That particular section 26 deals with the dying declaration. There is no change at all in the dying declaration. All the concepts of dying declaration, all the ingredients of dying declaration available in the old act has been reiterated. Only thing is that earlier it was numerical number, 32.1, 32.2, ಆ ರೀತಿಯಾದಂಥ ನ್ಯೂಮರಿಕಲ್ ನಂಬರ್ಸ್ ಇತ್ತು, ಸಂಖ್ಯೆಗಳಿತ್ತು. ದ್ಯಾಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ರಿಪ್ಲೇಸ್ಡ್ ವಿತ್ A to H, 26A to H. That is the only difference. The next one is, that is statement made under special circumstances. That is section 39. That particular section 39 has been included. That has been, that special circumstances has been included in section 28 to 32. There is no change. Only thing is that this particular section 39, what has been incorporated, what is available in Indian Evidence Act, in the new act, it is available as section 33. That is the how much of statement would be relevant. That particular section, there is a wrong mentioning of it. That particular section has been referred to also the Gajanan judgment, that is with respect of 65B. I will just try to give an example. The court, in that particular judgment, the court has given a direction to the telephone service providers, say, with reference to section 39 of the old act, saying that you need to keep all the CDRs. And whenever there is a direction, you need to identify the relevant portion, so much of statement, so much of relevant portion, and you have to produce. That is with reference to section 39, and that particular section has been retained as it is. The next one is the judgments of court. So that was in earlier legislation, that is Indian Old Evidence Act, it was section 42-44. That has been renumbered as section 34 to 38. Now, 34 to 38, there is no much difference. Only thing is that judgment of the tribunal was not included in the earlier Indian Evidence Act. The reason is that when the Indian Evidence Act was legislated in the year 1872, there were no tribunals. The Tribunal Act was legislated. The Tribunal Act came into effect after the independence. And for that reason, judgments of the tribunal is also relevant. That has been incorporated in this particular chapter, that particular subheading of judgments of court. Next one. Then the next one is the opinion of third person. That is, earlier it was section 45 to 51. That has been continued. It has been reiterated. And that is now section 39 to 45 under the same heading. Only thing is that the earlier, an expert could have been examined with reference to foreign law, science, art, identifying of handwriting, and finger impression. Now, there is one more inclusion, one more field is included, that is by way of amendment, that is any other field. With respect of any other field, in addition to foreign law, science, art, identifying of handwriting or finger impression, any other field also, the expert can be examined. For example, ನಮ್ಮ ಮನೇಲಿ ಎಲ್ಲರೂ ನೋಡ್ಬೋದು, ಮಕ್ಕಳೇನು ಅಂತಂದರೆ ಗೇಮ್ಸ್ ವಿಪರೀತ, ಗೇಮ್ಸ್ PS1, PS2, PS4 ಅಂತಾರೆ. ನಮಗಂತೂ ಗೊತ್ತಾಗಲ್ಲ ಅದು ಯಾವ PS1 PS2 ಅಂತ. ನಾನು ಕೇಳ್ತೀನಿ PS1 ಅಂತಂದರೆ ಪೊನ್ನಿಯನ್ ಸೆಲ್ವನ್ ಒಂದ ಅಂತ. ಇಲ್ಲಪ್ಪ ಇದು ಗೇಮ್ಸ್ನಲ್ಲಿ ಹೆಸರು ಅಂತ ಹೇಳ್ತಾರೆ. ಇಫ್ ಸಚ್ ಗೇಮ್ಸ್ ಆರ್ ವೆರಿ ಡೇಂಜರಸ್. By the games, a person, they can motivate and they can instigate the person who is in that particular game to kill another person or commit a suicide. In that event, that particular person who is expert in electronic record is one particular person, that is electronic examiner and all those things. A person who is well versed in the gaming, that particular person, if you want to examine, then it is possible now because any other field has been included. Okay, next one. The opinion of examiner was earlier part of section 45A. Now, that opinion of expert, which was part of section 45 in the old act, now it has been renumbered as section 39. That particular opinion of examiner of electronic evidence has been included in 39 too. The reason is very simple. The reason is that the expert of a particular person with respect of a document was included in 39. Now that electronic record have been elevated to the status of a document, elevated to the status of a primary electronic record. For that reason, that particular 45A, which was relating to opinion of examiner of electronic evidence, has been included in section 39 itself. Next one is very important. That is one particular change which we need to understand. That is character when relevant. That was earlier section 52 to 55 was used to deal with the character. when it is relevant. The same provision has been incorporated, same has been continued. However, there was an amendment in the year 2018 to the old act whereby section 53A was incorporated. So it was a habit of the defense counsel. We used to ask the question, we used to pose the question to the victim regarding her sexual experience. Then court used to avoid us posing that particular question. Then it was a legislative declaration was made by the amendment 2018 that past sexual experience is totally irrelevant. That same provision has been continued, not under the caption of section 53A, now under section 48. Now there is a proper numbering, that is section 48A. Section 48 is with reference to sexual experience of the victim. So with respect of POCSO cases and other cases, this is very relevant and important section. The next one is with respect of the chapter, the very important part, that is we had dealt with so far with the part 1. Now we are coming to the part 2, that is with respect of proof. So we are shifting from the relevancy to the proof. So the next stage is the proof. The proof was earlier part of 2. Now, because of the change in the parts, now it is under part 3. Now it is under part 3. This particular proof was comprising of section 56 to 100. Section 56 to 100. Now it is comprising, the new act is provided under the head, under section 51 to 103. So ಇಲ್ಲಿ ಒಂದು ಸ್ವಲ್ಪ ನಂಬರ್ಗಳು ಬದಲಾವಣೆ ಆಗುತ್ತೆ. ಇಲ್ಲಿ ಹೇಗೆ ಬದಲಾವಣೆ ಆಗುತ್ತೆ ಅನ್ನೋದಕ್ಕೆ ಕಾರಣ ಏನು ಅಂತಂತಂದರೆ 65A and B. 65A and B, that particular section has received a proper numbering. A annexed ಅನ್ನೋ ಥರ ಇಲ್ಲ, ಪ್ರಾಪರ್ ನಂಬರಿಂಗ್ ಸಿಕ್ಕಿದೆ ಅದಕ್ಕೆ. Then there is one particular declaration has been made, that is declaration with reference to the electronic evidence that is comprised in section 61. So since there is an addition, so now there is an increase in this particular chapter only. In the entire Indian Evidence Act, only in this particular chapter there is an increase in the number. The concept have remained the same, there is an increase in the number. So if we take here, that is section 56 to 100, the new ಅವತಾರದಲ್ಲಿ ಇರೋದು section 51 to 103. The chapter number 3, which deals with facts which need not be proved, judicial notice. That facts, judicial notice ತಗೊಳ್ಳುವಂಥದ್ದು, that comprises of 3 sections. That particular same provision is available in the new act. Same concept is available. Only thing is that there is one inclusion with respect of international treaty and international agreement which has been entered by India or decision taken at the international association or other bodies. For example, if we take the PMLA legislation, we are party to the Pulmonaro Treaty. Because of the Pulmonaro Treaty, that particular legislation has come into effect. Whatever the decision, whatever the FUT or the fatwa, those are the organizations. Some of them are the Indian organization, some of the international organization. So that PMLA is giving effect to the international treaty. There are so many such type of legislation. For example, NDPS is also giving effect to the international treaty. So when those treaties are there, that has been given a status of, it has been given a more importance, and it has given a status of judicially noticeable documents. So those are the judicially noticeable documents that you need to understand. Next one is with respect of oral evidence. First one is judicial notice yav togobeku annoduna, that was in the earlier part. The next one is with reference to proof oral evidence. There were only 2 sections. Here also there are only 2 sections. That is section 59 and 60. Now it is section 54 and 55. Now only thing is that after Amendment Act, electronic records are included in section 59. In earlier version itself, electronic records are included. So that same electronic record has been reiterated in the new act also. So now oral evidence which has been received through electronic mechanism, that particular oral evidence also a statement, it is also oral statement. ಒಂದು ವೇಳೆ ಯಾವುದೇ ರೀತಿಯಾದಂತಹ ಇಲೆಕ್ಟ್ರಾನಿಕ್ ಮಾಧ್ಯಮದಲ್ಲಿ ಸಾಕ್ಷಿಯನ್ನು, ನುಡಿ ಸಾಕ್ಷಿಯನ್ನು ಕೋರ್ಟ್ ಮುಂದೆ ಕೊಟ್ಟರೆ ಕೋರ್ಟ್ ಅದನ್ನು ರಿಸೀವ್ ಮಾಡಿಕೊಂಡ್ರೆ ಅದಕ್ಕೆ ಆ ರೀತಿಯಾದಂಥ ಸಾಕ್ಷಿಗೆ ಒಂದು ಅವಕಾಶ ಇದೆ ಅಂತ ಈ ಒಂದು ಹೊಸ ಲೆಜಿಸ್ಲೇಷನ್ನಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಓಕೆ, ಸೊ ದಟ್ ಈಸ್ ಒನ್ ಮಾರ್ಕ್ ಚೇಂಜ್. That is with reference to section 5960 of the old act, we have to understand with reference to the definition of evidence which has been given in this particular new legislation. Now the next one is, that is very important change after the oral evidence, that is documentary evidence. Earlier it was section 61 to 90 with reference to documentary evidence. Now it is 56 to 93. And anta tappagide, 56 to 93 under the head of documentary evidence. So here 61 to 73 there were 13 sections. Earlier there were 13 sections. Now under the head of 56 to 73, 56 to 73 falls under one category. Under this particular head it is with respect of 18 section. That is section 61 to 73 deals with the proving of the contents of the document. The first concept, what is the first concept, is that the primary evidence has to be produced. Best evidence has to be produced. The same concept has been reiterated here. Earlier there were 13 sections, now there are 18 sections. Where it has been increased is the question. Where it has been increased? The increase here is, the increase here is with respect of few of the sections, that is 65A, B, then various other sections with respect of electronic record, which has been provided with a new numbering, new numerical number. Now there is one particular change which we have to notice, that is section 57. This particular section 57 deals with primary evidence. This primary evidence earlier was in section 62. This section 62 was providing only two explanations. Please try to understand. It was providing only two explanations. Now section 57, which is earlier section 62, it provides 7 explanations. There are 7 explanations are there. Explanation 4 to 7 are all relating to electronic records. So these are all related to electronic record. ನಾನು ಈಗಲೇ ಹೇಳೋಕೆ ಒಂದು ಇಷ್ಟಪಡ್ತೀನಿ, ಒಂದು ಎಕ್ಸಾಂಪಲ್. ಒನ್ ಆಫ್ ದಿ ಎಕ್ಸ್ಪ್ಲನೇಷನ್ಸ್, ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಐ ಆಮ್ ನೌ ಕಂಡಕ್ಟಿಂಗ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಕ್ಲಾಸ್, ಆ್ಯಂಡ್ ವಾಟ್ ಎವರ್ ಐ ಆಮ್ ಕಂಡಕ್ಟಿಂಗ್ ದ ಕ್ಲಾಸ್, ಇಟ್ ಇಸ್ ಬೀಯಿಂಗ್ ವಿಡಿಯೋ ಬ್ಲಾಗ್. ಆ್ಯಂಡ್ ವೆನ್ ಇಟ್ ಈಸ್ ಬೀಯಿಂಗ್ ವಿಡಿಯೋ ಬ್ಲಾಗ್, ಇಫ್ ಇಟ್ ಈಸ್ ಸ್ಟ್ರೀಮ್ಡ್, if it is available in the Facebook or if it is available in the YouTube, then YouTube as well as Facebook, it starts recording. The person who is recording my class, it is available in his camera also. In his inbuilt camera there is a memory card. In that particular memory it is being recorded. That is one aspect. Another one is, it is also being streamed. If it is being streamed in the YouTube or Facebook, it will also be available in the server of the YouTube or as well as the Facebook. There will be a hashtag if I want to retrieve it. That particular recipient as well as broadcasting as well as streaming, now it has been considered as a primary evidence by virtue of amendment to section 57. Please try to understand. This is very important, because day in day out we will get lot of such cases, because you have to deal with the CCTV. Earlier what used to happen is that the CCTV, if you want to produce the CCTV footage, you produce the CCTV itself, then it used to be considered as primary evidence. Then if you want to produce the CCTV footage in a secondary forum, then you produce the pen drive, then 65B certificate. Now if there is a hashtag and this particular streaming is available in the YouTube or the Facebook, that can be considered as a primary evidence. Please try to understand. This is the marked difference. This is the 57. This is the 57 which is now available. That is in the earlier it was section 62 dealing with the primary evidence. That is the marked difference which has been made in this particular legislation, and explanation 4, 5, 6 deal with these things. Okay, next. The new act which deals with secondary evidence, this particular section secondary evidence, section 58 is with respect of secondary evidence of document, not secondary evidence of electronic record. So that particular section was having earlier only 5 parts. Now last one ಏನಾಗ್ತಿತ್ತು ಅಂತಂತಂದರೆ oral record anta, oral statement, oral record. Now there are 3 inclusion, that is oral admission, written admission, and the last one is examiner of a document who has skill in the examination of such documents. This is once again very important, that is that is with respect of secondary evidence. What used to happen is that, more particularly when the accounts, statement of account used to be produced, it used to be very lengthy and concise form as required under section 39 never used to be produced. Then we used to depend upon the advocates to give the explanation, or we used to depend upon our own skill. Now by virtue of this particular amendment, a chartered accountant can give the gist of that particular statement, and that particular statement, that particular statement can be considered because he would be the examiner, and whatever the statement he gives, he would be the examiner who has the skill in the examination of that document. If he provides his own statement in a concise form, then that can be considered as a secondary evidence. That is the one particular material change which has been incorporated with this particular section, with respect of this. Then next one is section 61. This particular section 61 is in the form of a declaration. It says that the admissibility of electronic and digital record. In the earlier legislation, it was only electronic record. Please try to understand. The new legislation, this particular new BSA, it not only provides for electronic record, it also provides for digital record. Now, what is the electronic record and digital record? I will just try to give one example. The Word document which is available in a computer system or a floppy or a particular compact disk, as well as the printout, if I produce it, then it is an electronic record. Because it is from a computer system, it has been generated. If that particular Word document, digitally, if I convert it into a PDF, and that particular PDF document cannot be altered, modified, that particular document would become a digital record. So the Indian Evidence Act includes electronic record as well as digital record. When Information Technology Act was when it was given effect to, it dealt with only electronic record. It has not dealt with the digital record. Now, Indian Evidence Act, that is a BSA, it not only deals with the electronic record, but it also deals with the digital record. Okay. The next one is, here there is a declaration. The legislature has made a declaration of law that nobody can deny a electronic record on the ground that it is in a electronic record. Nobody can deny an electronic evidence on that ground. For example, what used to happen is that the moment we used to produce the electronic record, the other side advocate used to raise his hand saying that I have an objection because it is an electronic record. Now, there cannot be a denial because it has been elevated to the status of a document. On that count, on that pretext, the denial is not proper. That is the declaration which has been incorporated. The one particular section has been dedicated. The reason is that they want to give more importance to the electronic record. That is the reason why section 61 is very important. The reason why section 61 is very important is that the moment electronic record is produced before the court, then it has to be accepted. So this is the one material change which has been made. The next one is the same thing. What I am explaining here is that it has assumed the status of document. Now here is, earlier section was, that is 65A, which was a declaration saying that electronic record you can produce before the court in the manner in which it has been explained in the section 65B. That was declared in section 65A. So now the 65A is section 62, 65B is section 63. So there is no much difference. Sorry, madam. Yes, madam. Yes, madam. Yes, madam. That is the next section, madam. That is the next section. The section 63 says that, if you are producing the secondary evidence of a primary electronic record, then you need to produce the certificate. That is what section 65B also used to say. That has been explained in section 63 now. Next thing is that, madam, is that section 63 is also refers to a schedule which is annexed to the Indian Evidence Act, the BSA. A schedule has been included. That particular schedule itself provides the form of certificate. What used to happen is that I used to file an affidavit or certificate under section 65B as per my whims and fancy, explaining so many things. Some of the offices used to file 2 or 3 pages of the affidavit in the form of a certificate, giving so many explanations. Some of the offices, in 2 lines they used to certify it. There was no uniformity, there was no standard. For that reason, taking clue from the Gajanan case, that has been incorporated as a schedule. The format of the certificate itself has been provided in the schedule. Now the question is, in which cases I have to provide? If it is a electronic record, if it is a primary evidence, electronic record which is a primary evidence, which has the status of a document, no certificate is required. The law is settled as per this particular legislation. If it is a electronic record, but it is not a primary record, but it is an electronic record which is in the form of a secondary evidence, in that event, 65B certificate is required. Now the question is, which is a primary evidence, which is the secondary evidence? If I have a CCTV footage, if that particular CCTV footage has recorded the entire event, if I produce the CCTV footage with the camera or with that particular device, then no need of 65B certificate, because integrity is intact and that particular device itself is available before the court for any examination. If the other side is contesting it, he can very much send it to the forensic lab or the scientific investigation. So in that event, it will remain a primary evidence. But if I want to produce output of that particular camera, I can produce the output in various forms, either in the form of pen drive, or in the form of CD, or in the form of a printout. That may be a color printer or a Xerox printout. In that event, the certificate under the 65B, we used to insist, the same insistence we can make under section 63. That 65B certificate, now it is available in the form of a schedule. Just, madam, since you have posed the question, I will just, that is one of the subject of this today's deliberation, that is Gajanan Koldkar judgment. What happened in that particular case? There was an election for MLA in Jalna, in Maharashtra. The one particular person succeeded, he was elected. The difference of votes between the elected candidate and defeated candidate was 250 or 250 odd votes. The person who was elected in that particular election, he presented his nomination after 3 p.m. after one particular day. The nomination was required to be presented only on a particular day before 3 p.m. But he submitted his nomination paper after 3 p.m., that is at 3:20 p.m. The defeated candidate, he requested for verification or examination of CCTV footage or the videography which was made on that particular day when the elected candidate submitted the nomination papers. Then when he received it, he came to know that not before 3 p.m. he submitted his nomination paper, and he has submitted after 3 p.m. Then that was one of the reasons to consider his election, the elected candidate's election, is bad in law. Then he went to the High Court. Then he challenged that particular election of that particular person. Then the High Court of Maharashtra declared his election as bad. Then there is one particular lady who was the returning officer. That returning officer was examined and she produced that videograph.
The certificate what she produced under Section 65B Act is 2-line certificate. This is the certificate I am providing. This is from the computer system, and this is, I am the person in charge. She has signed it. The other side, the elected person who approached the Supreme Court, his contention was that it is not a 65B certificate. Fortunately, that lady returning officer, she produced the entire videograph system, entire videography, or the camera itself before the court. Then the court said that when the primary evidence itself, primary electronic evidence itself has been produced, there is no need of 65B certificate. Then the Supreme Court further said that if you are producing secondary evidence of primary electronic evidence, then you need to produce the 65B certificate. Then there is so many comments. Justice Rohinton Nariman, then Justice Bal Subramaniam, they made so many comments regarding the 65B certificate, the vagueness of the 65B certificate that has been considered. There is a discussion regarding Canada legislation, UK legislation, USA legislation, then this hashtags, then this particular integrity of the document. All those things have been discussed in that particular judgment. Those things have been incorporated here. My personal feeling is that that particular legislation has been taken as a clue to amend this particular chapter. So if there is even if a person wants to produce the electronic record in the secondary evidence, it is very much possible. But if he wants to produce it, it is as per the schedule which has been provided. Earlier, what used to happen, madam, when a certificate is filed, we used to check that particular certificate in the teeth of Section 65B, whether it is proper or not. There are 4 requirements, and there is one 5th requirement. 4 are technical requirement, 5th one is non-technical requirement. So we used to compare with that, and whether the certificate is proper or not, then the admissibility we used to decide. Now, that 4 requirement, which is available in 65B, now new avatar is Section 63, it has been included in schedule itself. So our work has been reduced. Advocate's work also has been reduced. That means mechanically we cannot file that certificate. At the same time, once that particular certificate is produced before you, then you can very easy to verify it. That is the one difference which has been made. Next. Now, the next one is with respect of public documents, that is earlier Section 74 to 78. This particular public document has been incorporated in Section 74 to 77. Section 74 of the old Act used to deal with the public document, the private document. Now the Section 75 of the old Act deals with the private documents. That has been, number has been changed. Both these provisions, earlier there was a separate section for the public document as well as private document. So for private document, public document, there was one separate section. Private document, there was one separate section. But however, we have been told by our seniors as well as the teachers that both sections has to be read together. Now that particular, the eventuality has been clarified. Both these sections, public as well as private document, has been merged into one section. Now that is available in Section 74. Section 74, subsection 1, it deals with the public document. The next subsection, that is subsection 2, deals with the private document. So there are no 2 separate sections with respect of public and private document merged in one section, that is Section 74. Then the presumptions are available from Section 79 to 90, presumption as to documents. Those presumptions now available in Section 78 to 93. There is some changes which has been made to the presumption. Concept has retained the same. Some of the presumption with respect of telegraphic messages obliterated, removed forever. Then some of the sections relating to cessation of territory removed in entirety. Those sections have been removed in entirety. So old Act, now old Section 81 has been renumbered as Section 80. That particular Section 81 used to deal with the presumption as to gazette, newspaper and other documents. Now the gazette in the electronic record also has been considered as a valid document, and presumption can be drawn in that particular section as per Section 81. So now the Section 81 with respect of the electronic record has been included in the regular section. That particular regular section is renumbered as Section 81. Then the Section 82 of the old Act has been completely deleted. That is with respect of documents admissible in England. So the legislator have taken a decision to do away with that, because those are the documents which was earlier in 1872 were relevant. Now it is not relevant, so that has been removed. Next one is section 85A, B, C are incorporated by virtue of an amendment in the year 2000 in the teeth of the provisions of the Information Technology Act. That particular section 85A, B, C respectively available as section 85, 86, 87. So that is the reason why there is an increase in the number from 167 to 170. So that is available in the same form. Next one is section 88, telegraphic presumption as to telegraphic message, deleted. Then section 88A, old act used to deal with the electronic messages, that is the presumption as to electronic messages, that is with respect of the sender and recipient. That is the concept which was incorporated in section 88A. Now it is available in section 90. So section 90 ನಾವು ಭಾಳ ಈಸಿ ಇತ್ತು, 30 ವರ್ಷದ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ. ಸೊ ಆ 30 ವರ್ಷದ ಡಾಕ್ಯುಮೆಂಟ್ ಸೆಕ್ಷನ್ 90 ಅನ್ನೋದು ನೆನ್ಪು ಮಾಡ್ಕೊಳಕ್ಕಾಗಲ್ಲ. ದಟ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಸೆಕ್ಷನ್ ಈಸ್ ಅವೈಲೇಬಲ್. That particular section 90 is available in the form of section 92. In the form of section 92. The explanation was there in section 90 with respect of proper custody. That same explanation with regard to the proper custody, receiving from the proper custody, a document which has come from a proper custody has been retained in section 62 also. That is available in sections 92. Next one is section 90A, that is presumption as to electronic record if it is 5 years old. For public, any other document it is 30 years, whereas electronic record 5 years. Same 5 years validity, 5 years concept has been retained here, but it is in the form of section 93. So these are the presumption which is available in the new act. So the same concept of presumption, there are certain deletion, there are certain inclusion. Those inclusion was earlier in the form of amendment. Now it is available in a proper numbering and proper arrangement which is available. Next one is the exclusion of the oral evidence. The very important concept, that is when the oral evidence is excluded, when the documentary evidence is available. With respect of the exclusion of oral evidence by documentary evidence, the first best evidence principle, first rule of best evidence is that when if it is in a documentary form, document has to be produced, no oral evidence. That is captured in section 91 to 100. The same concept has been included. There is no change at all. There are no change at all in the new section, new act. That new act is section 94 to 103. So that is what has been written. There is no much. The last one is the production and effect of evidence. This particular production and effect of evidence was part of part 3. Now it is part of part 4. The earlier it was section 101 to 167. That has been renumbered as section 104 to 170. The last one is 170, that is with respect of repeal and saving clause. That repeal and saving clause has been added as a separate chapter. Next story. Now one more chapter has been added, that is what I was explaining. That is chapter number 12, dealing with the repeal and savings clause. Earlier this particular chapter was not available. Two sections, namely 113, dealing with the proof of cessation territory, and section 166 dealing with the power of the jury. The jury concept was earlier there. Wherever there is a presidency town, wherever Indian Evidence Act of 1872 was applicable, the jury concept was there. For example, Bombay presidency ಇಂದ ನಾವು ಯಾರಾದರೂ ಬಂದವರು ಇದ್ರು ಅಂತಂದರೆ ಜೂರಿ ಕಾನ್ಸೆಪ್ಟ್ ಇತ್ತು ಅಂತ ಕೇಳ್ತಾ ಇದ್ವಿ. ಯಾವುದಾದ್ರೂ ನಾವು ಲೋಕಮಾನ್ಯ ತಿಲಕ್ ಪಿಕ್ಚರ್ ನೋಡಿದ್ವಿ ಅಂದರೆ ಅಲ್ಲಿ ಜೂರಿಗಳು ಕೂತುದನ್ನು ಸಹ ನೋಡ್ಬೋದು. ಸೊ ಈಗಂತೂ ಜೂರಿ ಸಿಸ್ಟಮ್ ನಮ್ಮಲ್ಲಿ ಇಲ್ಲ. After the constitution, there is no jury system. For that reason, that particular provision that has been removed. So 165, judges can pose the question, that has been remained intact. There is one material change in section 165. Question should be relevant anta helidare. Obviously it is relevant. There was no need of incorporation, but it has been incorporated. Section 166, jury can pose the question anta helta idru. That particular provision has been taken away. That particular provision has been deleted because it is redundant. Next one is section 126. Section 126 of the old Evidence Act deals with the privilege relating to professionals. Nama privilege, ನಾವು ಮತ್ತೆ accused ಏನು ಮಾತಾಡ್ತಿದ್ದೀವಿ, it is a privilege communication. Those privilege communication are protected. We are immune from disclosing it. The same provision is incorporated here. There is no much difference. Only thing is that if that privilege communication has been made to my junior colleagues, made to the clerk in my office, interpreter in my office, that privileged communication extended to them also by virtue of section 127, that is in continuation of section 126. Now both those section 126, 127 has been merged into one section. That particular section is 132. There is no material change. Next story. Then the last one, very important according to me, 141 of the old act deals with the leading questions. That particular leading question aadmele, what leading question may not be asked, that was 142. What leading question may be asked, that was section 143. So 141, 142, 143 has been merged in one particular section. That particular section is available in section 146. So 146 comprises of 4 subsections. All the section 146 subsection 1 defines what is leading question, which is reiteration of the old law. Then 146 subsection 2, 3, 4 deals with the other aspects. Next. Then the presumptions, which was by virtue of an amendment, which was in the year 1983, and subsequent amendment with respect of presumption as to dowry death, 7 years, then presumption as to abatement of suicide, then presumption as to certain offenses, then presumption as to absence of consent in certain prosecution for rape. Those provisions have been given proper numbering, that is 115, 117, 118, and 120. The contents are the same. There is no change at all. The next one is this is the structure of this particular legislation. I have not dealt with the definition of document. I have not dealt with the definition of evidence also, that we need to understand with this particular judgment. This particular judgment is the law as on today. There are so many blogs are there regarding Bharatiya Saksha Adhiniyama. More particularly, if you go to YouTube, if you just type Bharatiya Saksha Adhiniyama, you will get number of the videos as well as the material. In one of the videos, a question is asked whether this Arjun Panditrao Kotkar is a good law by virtue of the new BSA, that is the BSA. The speaker in that particular blog so succinctly explained that this particular judgment, even today, even after the new legislation, holds the fleet. So it is relevant. This particular judgment is relevant. The concept what has been explained in Arjun Kotkar has been incorporated in this particular Indian Evidence Act. That is section 57, section 61, 62, 63, and schedule. So that is the reason why we need to keep that particular judgment. We need to follow that particular judgment. While following this particular judgment, we have to pose ourselves, whenever the electronic records is produced, whether it is a primary electronic record. If it is a primary electronic record, then certificate is not required. If it is a secondary electronic record of a primary electronic record, then immediately 63 will kick in, as well as this judgment will comes into play. Next one here is, just I want to give a brief background next to it. The year 2000, I was explaining this particular amendment, that is Information Technology Act. Then Information Technology Act regulated electronic transactions. For example, ಏನಾಗುತ್ತೆ ಅಂತಂದರೆ ನೀವು ನೋಡಿರ್ಬೋದು, ಸ್ವಿಗ್ಗಿ ಬರುತ್ತೆ, ಸ್ವಿಗ್ಗಿಯಿಂದ ನಿಮ್ಮ ಮಗ ಯಾವುದಾದ್ರೂ ಆರ್ಡರ್ ಮಾಡಿ ಕೂಡಲೇ ಇಮಿಡಿಯೇಟ್ಲಿ ಅಂತ ಕೊಡ್ತಾನೆ, OTP ಹೇಳಪ್ಪ ಅಂತಾರೆ. OTP ಹೇಳಿ ಕೂಡ OTP ಕೊಡ್ತೀವಿ. OTP 33445 ಅಂತ ಹೇಳಿ ಅವ್ನು ಟಕ್ ಟಕ್ ಅಂತ ಬರೀತಾನೆ, ಅದು ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ, ಮುಗಿದು ಹೋಗ್ಬಿಡುತ್ತೆ. ಸೊ ದೆರ್ ಇಸ್ ಎ ಡೆಲಿವರಿ ಅಂತ. ಸೊ placing order as well as delivery, it is through the electronic transaction. Through OTP, through your mobile system you are generating. So there is an offer, acceptance, everything is through electronic transaction. So day in, day out, we have been entering into electronic transaction. Even if you board a train also, you are entering into an electronic transaction. So now the question is, whenever there is a electronic transaction, these OTPs, these receipts, are also will get the evidentiary value by virtue of the amendment. So electronic transaction are the order of the day, and we have to prove the cases through the electronic transaction only. Next only. So for that reason only, this BSA has been amended, facilitating the acceptance of electronic evidence. Facilitating the acceptance of the electronic evidence. ಇವಾಗ ಪೆಟ್ರೋಲ್ ಫಿಲ್ ಅಪ್ ಮಾಡಿದ್ರು ಸಹ ಅವ್ನು ರಿಸಿಪ್ಟ್ ಯಾವ್ದು ಕೊಡ್ತಾನೆ ಅಂದರೆ ಅವನು ತನ್ನ ಹ್ಯಾಂಡ್ ಹೆಲ್ಡ್ ಮಷೀನಿಂದ ತೆಗೆದುಕೊಡ್ತಾನೆ. ಸೊ ಮೊದಲೇನು ಅಂತಂದರೆ ಸೆಕೆಂಡ್ರಿ ಎವಿಡೆನ್ಸ್ ಏನಂತ ಇತ್ತು, ಸೆಕ್ಷನ್ 65B ಯಲ್ಲಿ computer system generated, if it is printout is generated from computer system, no. Now what it says that computer system or communication devices, if it is generated from a communication device also, for example, handheld machine ಇಂದ ಅವನು ಪೆಟ್ರೋಲ್ ತುಂಬಿದ ಮೇಲೆ ಹರಿದ್ಬಿಟ್ಟು ರಿಸಿಟ್ ಕೊಟ್ಟರು ಸಹ that particular printout holds a good and it is an electronic record and that can be produced as a secondary evidence. Now the question is, as per this particular judgment, that is Pandit Rao judgment of Kotkar judgment, Supreme Court. What Supreme Court says that in that particular judgment is that you can produce this particular document as a first stage of secondary evidence. Make a declaration that I don't have that hand-holding machine or that primary evidence. In that event, you make a request to the court seeking a direction to that particular person to produce that primary evidence. If he fails to produce it, the concept of secondary evidence, that is notice to produce, everything will follow. In that event, when the notice is given, if there is a failure on that particular person's part, then you mark it as a secondary evidence. Once it is marked as secondary evidence, and the other side objects for it, subject to objection anta mark ಮಾಡ್ತೀವಲ್ಲ ನಾವು, then there is a concept of reverse burden which is being developed. Then that other person has to prove why I am objecting it. Because of section 61, it declares that the electronic records are also documentary evidence. That is the mark change. If the raising objection was very easy. Now if I raise the objection, it will be marked as subject to objection. The burden will cost on him. If the burden is shift on him, he is supposed to prove why he is objecting for it. If he is unable to prove, then it will elevate to the status of documents. So that is the section 57, that is the section 61, as well as 62 and 63, as well as schedule appended to section 63. Next story. Now, before 2000, just we need to go before IT Act. Then when it was electronic record, for example, whatever the electronic record, for example, marriage recording and all those things, the cassette along with the devices were required to be produced. It was a gigantic task. We never used to produce it and it was never used to be accepted by the court. That was earlier to year 2000. After 2000, cassette we used to produce with 65B certificate. Now after 2000, this is the scenario. After 2023, after this particular legislation, if there is a hashtag, for that particular marriage, entire marriage event is available in the YouTube with a hashtag, then I can produce that particular electronic evidence as a secondary evidence with that particular hashtag, calling upon the other side or the calling upon the person who has the custody to produce that particular document. And if he is unable to produce, if that particular hashtag remain intact as well as available in the server, which can be with one click, if it can be seen, that particular document can be looked into. Please try to understand. That is the reason why, along with the electronic record, the word digital record has been incorporated in the Indian Evidence Act. Now the next one is the section 61 ಹೇಳಾಗಿದೆ, ಮುಂದೆ ಹೋಗಿ. Additionally prescribed for the format certificate. Next ಹೋಗಿ. The one thing, next ಹೋಗಿ, ಮತ್ತೆ ವಾಪಸ್ ಬರೋಣ. Here is what I was explaining is that earlier Evidence Act, the definition of evidence was amended in the year 2000, giving effect to the electronic record. There was no change or there is no amendment to the word document in the earlier act. Now there is a change in the definition. ಮುಂದೆ ಹೋಗಿ. Now this particular change in the definition includes electronic record as well as digital record. What is this electronic record and digital record? Just I am trying to give some of the example. First one is, if it is an information, if it is created, for example, by typing we create it, and if it is stored in the computer, and if it is managed and accessed, that is CSMA, that is a concept called as CSMA. In that event, it is an electronic record. Those are emails, Word document, spreadsheet, that is the Excel sheets, scanned documents, multimedia files, that is audio videos, and databases. These are all traditional electronic records. Sorry, I'm using the word traditional. This is my word. In any of the legislation or any of the book, it has not been explained. For better understanding, I'm saying that it is traditional electronic records. The next one is, if one of the features of this is, these are in the form of a text, that is a typed in text, or it was in the video images only, and it is managed and stored. Next one is the digital record is information that is created, managed using digital technology itself. For example, I get a message, I receive a Word document. That particular Word document is in the form of a text. I can amend it. You can also amend. I can also amend. Email, I can forward it to anyone. While forwarding, I can make so many changes, and then I can forward it. That is possible. That is the usually we used to follow. After amending the Word document, with digital help, I can convert the Word document into a digital document, either in the PDF or various other form. That particular record is digital record. That has been captured here. If it is in the PDF form, then it is a digital record. If it is in the Word document, then it is an electronic record. Both have been accepted here. The one is from how it has originated, how it has been stored, how it has been managed is the question which we need to understand. The next one is digital documents. Most of the time, either it would be in the PDF form, DOCX, docs ಅಂತ ಕರಿತೀವಿ, ಎಕ್ಸೆಲ್ ಎಕ್ಸ್ ಅಂತ ಕರೀತಾರೆ. ನೀವು ನೋಡಿರ್ಬೋದು ಬಹಳಷ್ಟು ನಮ್ಮ ಮಕ್ಕಳಾಗಿರ್ಬೋದು, ನಮ್ಮ ಕಸಿನ್ಸ್ ಆಗಿರ್ಬೋದು, ಯಾವುದ್ರಲ್ಲಿ ಇದೆಯಾ ಅಂತಂತಂದರೆ ನಾನು ಈ ಲ್ಯಾಂಗ್ವೇಜ್ನಲ್ಲಿ ಇದ್ದೀನಿ ಅಂತ. ದೀಸ್ ಆರ್ ದ ಲ್ಯಾಂಗ್ವೇಜಸ್, ದೀಸ್ ಆರ್ ದ ಡಿಜಿಟಲ್ ರೆಕಾರ್ಡ್, ದೀಸ್ ಆರ್ ದ ನೆಕ್ಸ್ಟ್ ವರ್ಷನ್ ಆಫ್ ದಿ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ರೆಕಾರ್ಡ್. These are also media, digital media is also available, that is in the form of photos, videos, that is used with digital cameras, various other forms of digital camera. For example, if I need to enter inside the Supreme Court, there will be a camera. That particular camera captures my photo, then it allows me. Certain cameras with face recognition, it allows me to enter one particular premises. Those are the digitalized cameras. Those digitalized cameras are considered as digital record, not as electronic record. Next one. Then there are various digital databases are there. Those databases are management systems. For example, a judgment pronounced by you, which is pronounced by you, immediately on the same day, you will upload it to central server. In this, with your digital signature, you upload it to the central server. What is available in the central server is a digital record. What is available in your system, in your computer system or laptop, is a electronic record. The reason is that that particular digital record which has your digital signature, it is also a primary electronic evidence with hash value. For that reason, this is what has been incorporated. Then digital transaction, all those things. It is, these digital records are easily accessible. I will give you just one more example. For example, I am typing something on my computer. The moment I type, I was saving it in with one particular heading, that is BSA1 or BSA2. Immediately there is a loss of electricity. Then immediately my laptop has switched off. Then I will switch it on. The moment I switch it off, then that particular very same computer would ask, there is a compatible document which is available at this particular place, whether you want to retrieve it. That particular compatible document, which I can retrieve it, which I can look into it, is a digital record. It looks very simple. But that would be the next document. That would be the document which is likely to be produced before you. For example, the mobile has been snatched from me the moment I landed in Bengaluru. That particular mobile has been taken. In that mobile, if you open it, everything is empty. There is nothing in that mobile. But digital footages are available. Digital footprints are available that can be retrieved. The temporary files, old files, which are available in various forums, which can be retrieved. With the very same mobile, one can connect to various other sources, various other emails, various other transactions. From those servers, one can retrieve it by the forensic experts, by the digital experts. Once that is retrieved, it will get a concept called digital record that can be produced along with the mobile. And in that event, if it is not available in the mobile, if it is available in the server, as per this particular Gajanan judgment, as per section 39, you can call upon those intermediaries, those particular person to provide those material. If they fail to provide, or if they provide the details, then it will get the status of a primary evidence. So that is the concept which has been incorporated here. Next one. So as per the section, various concepts have been included. That is, server logs has been considered as an electronic record. Then the laptop, smartphone, messages, website, locational evidence. For example, I am here. If my GPS is on, my location is on, where I am here can be identified with longitude and latitude. And where I am sitting here, that can be identified. So locational evidence. With the CDR, we used to identify it. Now with GPS also, the locational evidence can be identified. Voice mail messages. Naan barta idini anta navu ಏನು ಹೇಳ್ತೀವಿ, whatever the statement we make and then send the voice messages, that is also valid if it is stored on a digital device. Then this is the status which has been given to the documentary evidence and the electronic evidence and all those things. What is the time available, I don't know. If it is 20 minutes. Okay. Then if we take this particular sections, section 57, I will try to dissect it. It would become easier for understanding. Munde hogi. First explanation is, please hinde bani, where an electronic or digital record is created or stored and such storage occurs simultaneously. I gave an example. Such storage takes simultaneously. For example, I am delivering the class here and it is also streamed elsewhere, that is YouTube and some other place. In that event, the YouTube which is available, by virtue of an explanation 4 to section 57, it is a primary evidence. Please try to understand. So this is a very interesting explanation which has been given. For example, you have delivered a judgment, physically you have signed it, which is available in the file docket. At the same time, you have taken, it is also available in the electronic form. Then you have affixed your digital signature. The digital signature signed judgment, which is all available in the server. That what is available in the server is a primary evidence, primary electronic evidence by virtue of explanation 4 to section 57. This is the mark difference. Next one. Then the second one is where an electronic or digital record is produced from proper custody. Such electronic and digital record is primary evidence unless it is disputed. For example, I have my mobile. This is very, it will create havoc, let me tell you. There is so many criticism to that, and we are going to, it will be a challenging situation for all of us, not only for the judges, for us also. He says that this is from my mobile, I am producing it. And that particular document I am producing it, and he says that it is a primary evidence. If it is marked, then it will become a primary evidence explaining a proper custody. If I explain proper custody, it is a primary evidence. Unless it is disputed, if the other side disputes it, then it will be marked by virtue of section 61, but it will be marked with the dispute. Then the burden will be on both the person, because he is supposed to lay the foundation regarding the admissibility of the document. If he prima facie satisfy the admissibility of the document, the person who is producing it, the burden cast upon the other person. Then he is supposed to say why it is not admissible. First thing is that raising of an objection by the other side is very important. That is what explanation 5 to section 57 says. The moment an electronic record is produced, if it falls under the category of explanation 5, if the objection is raised, it will be marked. That objection has to be considered later regarding the admissibility. That is what it says. Next one. Next, hinde hogi. Where a video, where a video recording is simultaneously stored in electronic form and transmitted, or broadcast or transferred to another, each of the stored recording is a primary evidence. If it is simultaneously stored, if it is stored standalone, that is one aspect. That was the earlier concept, standalone word used in the section 65B. So standalone nalli iddaga alli matra record agittu antandre whatever the outputs, whichever form, whether it is in the floppy form or in the CD form or in the pen drive, that was considered as a secondary evidence. But here, if it is simultaneously recorded, at different places, at different, not different times, simultaneously, each is considered as a counterpart which was available in explanation 1 of the old primary evidence. That is the status which has been given. So that is one explanation, that is with respect of explanation 6 to section 57 of BSA. Next, where an electronic or digital record is stored in multiple storage spaces. This is multiple storage spaces very important. For example, I have a mobile, I am using WhatsApp. At the same time, with that particular WhatsApp, I am also accessing through my laptop. Then there are 2 storage places. One is storage place in my mobile itself. If I am accessing simultaneously or also I am accessing on my laptop, then there is a storage. Temporary files also will be stored here. In that event, both those places output or both those places are considered as primary evidence. Next one is the cloud. Most of the time, we considered cloud as a new technology. For example, I have purchased a ticket. I have purchased a flight ticket. The flight ticket, what is the printout I have is one particular thing. That particular flight ticket, when I was booking, that particular temporary file is available in my laptop. The same time, that flight ticket, the regular file, all the files are also available in the server of that particular agency, that server of that particular flight company. That particular server as well as the details available there in the cloud forum is also primary evidence. My document is also primary evidence as per explanation 7. So these are the 4 explanations which has been given. These are the explanation which is added to the section 57 with respect of primary evidence. So the primary evidence concept has been enlarged and it has been various digital forms have been included. Digital devices also have been included. Next over here. So by virtue of that, the parity has been given to the electronic record to that of the documentary evidence. And the same legal effect, the terminology used is legal effect, validity, enforceability. Same legal effect, enforceability, validity of the documents has been given. Then the section 62 is with respect of the contents of the documents. Now, with respect of contents of electronic records, proving is very easy, not so challenging. It is very easy. Now, earlier there was only computer system which was available in 65B certificate, 65B in the old act. Now, in addition to the computer system, communication device also has been incorporated. So next one is scope of devices have been enlarged, and this scope has been included so many aspects. So 63.4 is the new provision with respect of testing the validity or the integrity of the electronic record with respect of certificate submitted by the party. Okay. And next one is change is that earlier was that a responsible official position, the person who is in a responsible position, he was required to issue the certificate. That has been relaxed. That particular concept has been relaxed. Now any person in charge of the computer, for example, if earlier what used to happen is that the person who is heading that particular institution, who is the owner of that particular computer, or who is actually owner of the computer, he was required to issue the certificate. Most of the time what used to happen is that if the CCTV footage has been produced by the police, the owner of the premises was required to give the certificate, and that particular owner never used to be in that particular premises. And the question used to be posed by us, appearing for the accused, that whether you are aware of this certificate, whether you are aware of this footage, whether you are you have acquittance with the computer system. that age-old person or any person, he used to say that, I don't know how to use the computer. Now that has been relaxed. A responsible official position has been replaced with the terms person in charge. If there is a particular person, if he is in charge of that particular computer, a manager, accountant, or any worker in that particular premises can give the certificate. That is what has been incorporated. Now there is one more thing which has been included, that is electronic signature and digital signature. It is a reversal, it is a bit different. This is the last concept which I need to explain. Now, if you have seen, if you have received the airmail or couriers which have come from the outside India, which you have received it, then the person, a delivery boy will deliver that particular cover to you. Then he will ask you to sign on a screen. He will provide you a stylus. A pen he will provide, electronic pen he will provide. With the help of that electronic stylus pen, you need to sign on the screen. Immediately that signature will be captured. That particular signature is the next version of signature. That has been also recognized. The digital signature, what you have been affixing, or the digital signature, what we have been affixing while issuing the notices. Digital signature, what we are affixing while submitting our income tax returns, are the authenticated digital signature with the certificate issued by an appropriate authority. For example, individual, there is a Mudra is an agency, Government of India sponsored agency. There we go, then obtain a digital certificate. Then with that particular certificate, we affix our signature. There will be a details of our certificate when the license has been issued and all those things. It is a encrypted digital signature with unique features. The electronic signature is a physical signature with using a stylus pen or various other pens. Or an electronic signature, if it is not the stylus pen, with my hand only I can also sign it. So those signatures are also recognized under this particular legislation. So that is one more mark difference. So that is the one concept which has been captured here. So with these things, whatever the subject which was given to me, whatever the time which has been given to me, I have tried to explain with the BSA. BSA is a new legislation and definitely a very important legislation. We are going to have a very good judging, for you people will have a judging experience. We will also have a wonderful time. Yavaga 2000 legislation bandaga, then we were under the impression that this is another legislation which will not affect our professional life. It will not give much, we are not required to give much importance to this legislation antkonde now bundvi. But Information Technology Act is being used by us in our day-to-day professional life. Definitely this BSA will change the concept of advocacy, change the approach of judging the cases. It will help us, it will help you people in administration of justice. Thanks one and all for giving a wonderful opportunity and addressing you people.
Thank you, sir, for that wonderful session. On behalf of Karnataka Judicial Academy and on behalf of all the respected judicial officers and also on my behalf, I extend warm thanks to my friend and my classmate, Madhukar M. Deshpande, advocate, for enlightening all of us on this subject. Thank you very much, sir. I request Amruta Madam, Assistant Director, Karnataka Judicial Academy, to hand over the momentum. Thank you, sir. Now we have a tea break. We shall resume in this hall by 12 for the next session.
Good morning, all the respected Honorable Principal District Judges, Senior Civil Judges and Civil Judges. On behalf of Karnataka Judicial Academy, I welcome Shri S.R. Somashekar sir, retired Principal District and Session Judge, and I request sir to address the officers on new dimension in assessing the relevancy of facts, primary and secondary evidence, oral evidence and other allied reforms, role of a trial judge under the Bharatiya Sakshya Adhiniyama 2023. Over to you sir, thank you.
I have requested the officers, having regard to my age and low voice, those in the back rows may not be able to hear. Forget the protocol, even if they are juniors, they can come and occupy the front rows, because the front rows are vacant. Honorable judges are not there today. It will be easy if you come near. If you find any difficulty in hearing me from here, I am prepared to go there. Okay. Happy to see all old friends, brothers, sisters, sons, daughters, and if I continue to come to the academy for another 10 or 12 years, maybe granddaughters and grandsons also. I must thank the past and the present directors of the academy and all their team for continuously involving me in all programs for the last 8 years. It was in June 2016, exactly 8 years back, I retired. Since then, I am involved in all foundation courses, all such special programs and workshops. Maybe a few subjects themselves excluded me because of my inability to speak on those subjects. The subjects excluded me. Academy never excluded me. So I must thank the director of the academy and his entire team, both past and present, for continuously involving me in all these programs. My association with the academy has kept me healthy, physically healthy, mentally agile, legally updated. So therefore I owe it to the academy. I owe it to the young officers also, because they frequently call me and make me to read. So I should also thank them. Now, the Parliament, rather the medical science and technology has advanced so far that the condition of the fetus can be predicted by ultrasonic tests. Now, what was in the womb of the Parliament was predicted. Triplets were found in the womb of the Parliament. Parliament conceived those triplets on 9/8/2023. Now the triplets are ready to come out on 1/7/2024. It is very difficult for a mother or for a pediatrician to rear a single child itself. Still more difficult if they are twins. If they are triplets, all the more difficult. Unfortunately, one of them or all the three of them or two of them or whatever it is may be deformed. Other may be well developed. The parent cannot say, well, the father particularly cannot say, you are the mother, you had given birth to a deformed child, it is for you to take care of the child. The pediatrician cannot say the parents that you are the parents of the deformed child, we only take care of the well-developed baby. Well, fortunately for us, in the trial judiciary, we have got good pediatricians who are prepared to take care of all deformed legislations, well-developed legislations also. The reason why I am telling this is only this. Of the three enactments, I do not find much of a change in the Bharatiya Sakshya Adhiniyama. You have been hearing people for the last 3 days. We have also gone through those three enactments. There is not much of a change in the law of evidence. A simple rule, if it is section 5, subtract 2, you will get 3 here. By and large, you will get the same thing. Here and there, a few changes. What was 168 in the old Act is 167 is now 170. It is mainly because some of those sections like 88A, 88B with regard to electronic evidence have all been given an independent number. That definition sections 3 and 4 interpretation class, they have all been put in section 2 definition and section 170 for repeal and savings. So 167 has become 170. Not much of a change here and there, maybe a few things. Penal, that is Bharatiya Nyaya Samhita, I am yet to go through. Then as far as Bharatiya Nagarika Surashya Samhita is concerned, there are certain areas where, particularly for the magistrates, there is some problem with regard to these private complaints and other things. A strange provision that the accused needs to be heard before taking cognizance. As it is with regard to cognizance, we are required to take cognizance of several conflicting decisions, and that is posing as a problem for us. And now a further problem by this new law saying that before taking cognizance, an accused needs to be heard. My only advice to the young officers is this: deal with those situations boldly and confidently. If you have not still any problem, the resource persons at the academy are always there to help you and guide you to the best of their ability. You cannot think of a case law right now. The Act is yet to come into force on 1/7/2024. It is too early for the High Court or for the Supreme Court to give its opinion about some of those provisions. So you will have to do something about it, boldly, honestly and confidently. Leave it. Let the High Court or the Supreme Court take its view, and that will be the law for us. So therefore, let us not hesitate. ಇದು ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ, ಅದು ಸಾಲ್ವ್ ಆಗೋವರೆಗೂ ನಾನು ಡಿಸೈಡ್ ಮಾಡಲ್ಲ ಅಂತಂದರೆ ಪ್ರಾಬ್ಲಮ್ ಹಾಗೆ ಉಳಿದ್ಬಿಡುತ್ತೆ. ಯು ಮಸ್ಟ್ ಮೇಕ್ ಅನ್ ಆನೆಸ್ಟ್ ಅಟೆಂಪ್ಟ್ ಟು ಡೂ ಇಟ್. Well, to the best of our ability also, the resource persons at the academy are always ready and willing to help you. They will, to the best of their ability, guide you in that regard. Don't be diffident. This is my advice to the young officers. Seniors will certainly manage. Now, as far as today's subject is concerned, I find it a little difficult to understand the scope of it. The reason is new dimensions in assessing the relevancy of facts. I do not find much of a change in the provisions relating to the relevancy of facts in the Bharatiya Sakshya Adhiniyama. But at least we should know what the old dimension was before we go to the new dimensions. Maybe here and there I may tell you something as to how some few additions and alterations need to be looked into. Civil judges here, mostly newly recruited, have heard me in the Judicial Academy when I had occasion to speak to them about the Evidence Act, or when I seized an opportunity myself to tell them something about the Evidence Act as and when an occasion arose. They have heard me sometimes. It will be a repetition for them. Kindly excuse me for that repetition, since I had no occasion to tell this to the senior judicial officers. I have chosen this opportunity to tell it. Now, the subject itself is relevancy of facts. So what I am reading from a book is not altogether irrelevant. We have a book on theory and practice of psychological testing. There is no need to note it because it is difficult to get that book also. Not worth spending money on this book. It is essentially a textbook for those who are doing post-graduation in psychology and M.Ed and other things. For my own reason, I had something to do with educational psychology, and therefore I bought this book on 21/2/2018, about 6 years back, for my own thing. There is a chapter in this. This is authored by Americans, some Freeman or something, Frank S. Freeman. Americans long back themselves long back itself had devised aptitude tests for various professionals, lawyers, medical professionals, engineers, like this for teachers, etc. What is it that the author has to say? what is the kind of an aptitude that a lawyer requires? Aptitude in law. Aptitudes in law. Tests in this field are aptitudes in the same sense, or aptitude tests in the same sense as are those in the field of medicine. What does it mean? All of us have gone to a doctor at one point of time or the other. We have taken our family members also to them. Particularly when the patient is old, he does not confine himself to the present problem that has confronted him while giving history to the doctor. He gives various details. Something happened about 2 years back, 15 days back, he attended a marriage, he ate something, yesterday he ate something. By the time he comes to the crux of the problem, the doctor is forced to spend 15 or 20 minutes. From a mass of those irrelevant details or data which the patient gives, the doctor has to cull out the relevant and find out what the disease is, prescribe medicine, diagnose and then prescribe. This is precisely what happens to a lawyer when a client goes to him. He gives several details. It may be a criminal case, he gives details of his property. It may be a civil case, he gives details of some case in the family, 498 or 304B. So a lawyer has to exclude all of them. All the more difficult is for a judge, particularly on the civil side. For various reasons, the provisions of Order 6 CPC, which require pleading to confine only itself to facts, material facts and evidence, is not done. We have our good friend in the commercial court, Mr. Surendranath. He must have seen how long the plaints in the commercial suits are. Even those petitions under Section 9 are too long. Anybody else here in the commercial court, or at least outside Bangalore? I think Mr. Anand said you were also in the commercial court at some point of time. Elsewhere, no. Your sister was in the commercial court at Ballari. I think you were in Chikmagaluru, you were in charge of the commercial court. We had several. In fact, the very first program in this auditorium was for these commercial courts. It's so difficult. No, at the time of framing the issues itself, you will have to prune those relevant those facts and find out what the relevant facts are. See this. Psychologists and others concerned with the problem of testing aptitude for the study of law agree that the following abilities are most important. I want the younger members of the judiciary here who have already heard me about this. It's only refreshing my memory and refreshing your memory also. What are those abilities that are required for a lawyer, obviously for a judge also? Reading rapidly and comprehending relatively difficult material. This is absolutely necessary because 30 pages of plaint, 20 pages of plaint, bail petition and all that, you are required to pass an interim order immediately, some direction matter, law pleadings, voluminous evidence. A kind of rapid reading is also necessary. Comprehending relatively difficult material. Some provisions in these new laws are relatively difficult to understand. Something like trial in absentia, procedure regarding private complaints. Memorizing and accurate recall. Even for applications for temporary injunction and other things or bail, anticipatory bail, at least we should know the provisions. Immediately we can't, though we are not expected to know the provisions of various other enactments, at least for CPC and CRPC we should be able to recall those provisions. Reasoning by analogy, all the more important. The most important thing is discriminating between the relevant and the irrelevant in a mass of facts, both while recording evidence and at the time of framing the charge or issues. I have given a simple formula for the junior officers. Well, at their level it is a little difficult to control the lawyers while recording evidence. Well, once one lawyer says relevant, another says irrelevant, it's a little difficult. All of us know the difficulty there. But at the time of writing the judgment, you are not under anybody's control or fear. At the time of framing the issues, you are not there. You have no control over the pleadings. Though you can have some control over evidence, practically it is difficult. I have a simple formula for them. At the time of writing the judgment, exclude the irrelevant, include the relevant, and then conclude, for which process you are not precluded by anybody. Please remember that. Then, between the relevant and irrelevant, reasoning inductively and deductively, and facilitating in acquiring and using vocabulary is equally important. Now, let me deal with this. The title is New Dimensions in Assessing the Relevancy of Facts, Primary and Secondary Evidence, Oral Evidence, and Other Allied Reforms, Role of a Trial Judge. Quite a long subject. In fact, this subject is split also. The Honorable Chief Justice of India wrote a letter to all the Chief Justices in the country to frame, suggesting given the training module, more or less the subjects you find in the timetable are a reflection of the module given by the Supreme Court. In fact, for this session, even documentary evidence was included there. Rightly, Mr. Marathe thought that a special session with regard to digital evidence and electronic evidence, because I have my own difficulty to speak about it with some confidence, and Mr. Madhukar Deshpande has spoken to you in extensive about it, documentary evidence, digital evidence, and all that. So, in fact, to that extent, my burden is relieved. Now, well, all of you know these basic things. The Evidence Act divided into three parts: relevancy of facts, proof of facts, production and effect of evidence. Now, the Evidence Act of 1872 had those three parts specifically. Though the first part itself was titled as Part 1, Relevancy of Facts, a few sections were definition sections, short title, extent and commencement. Again, from 5 to 55, it was styled as Part 1 there, Relevancy of Facts. Now, what you find in this Bharatiya Sakshya Adhiniyama, here afterwards I will say it as BSA for short, that BSA, Part 1 is those preliminary things. Part 2 is Relevancy of Facts. There it is 5 to 55, it is here 3 to 50. The second part in IEA, that is Indian Evidence Act, is Proof of Facts. Here it is Part 3. There Part 3 in IEA is Production and Effect of Evidence. Here it is Part 4. Whatever it is, here also we have totally three parts. Don't go by the part number. We have three parts. One dealing with relevancy, other with proof of facts, third with production and effect of evidence. Now, I don't think that there is need to refer to all these sections, because the title is New Dimension in Assessing the Relevancy of Facts. Ultimately, it borders on appreciation of evidence to some extent. Though it is in the context of the criminal laws this program is arranged, maybe incidentally I may have to tell you something with regard to civil cases also here. If you are armed with the barracks, please have a look at section 6 of BSA corresponding to section 8 of IEA. Section 6 of BSA. Motive, preparation and previous or subsequent conduct. Any fact is relevant which shows or constitutes a motive or preparation for any fact in issue or relevant fact. Subsection 2 is of some importance. The conduct of any party or of any agent to any party to any suit or proceeding in reference to such suit or proceeding, or in reference to any fact in issue therein or relevant thereto, and the conduct of any person, an offence against whom is the subject of any proceeding is relevant, if such conduct influences or is influenced by any fact in issue or relevant fact, and whether it was previous or subsequent thereto. Well, you have in the academy on various occasions heard me and others telling you that if a particular kind of evidence cannot be brought under that old section 27 as a fact discovered pursuant to the information furnished by the accused, it can be still relevant under section 8 as subsequent conduct of the accused. For today's purpose, illustration H may be material for us. The question is whether A committed a crime. The fact that A absconded after receiving a letter warning A that inquiry was being made for the criminal and the contents of the letter are relevant. We have section 41A CRPC. Corresponding provision in BNSS is 35(3) to 6. 41 capital A CRPC, the corresponding provision in the BNSS, that is Bharat CRPC, is 35(3). All of you know it, Arnesh Kumar case and all that, notice is required to be given under section 41A and all that. That's an indication that the police are searching not only for the criminal but also for something. Now he absconds. Sessions judges who have dealt with cases relating to circumstantial evidence know that abscondence by itself, though is a weak piece of evidence, it is also a circumstance in the chain of circumstance which you can take note of. Maybe a weak kind of evidence, totally cannot be ignored. So now what happens in this context? Notice is issued under 41A or 35(3). Or information is otherwise known that such notice is being contemplated or being issued or they are in search. He absconds. Right. Maybe in the process he also sends a mail or a WhatsApp message to his friend or relative saying, well, I have some information, I am leaving. He leaves Bangalore, goes to Mysore or something. On the way he sends a message or a mail to one of his relatives or friends saying that he is going there, hiding or something. I am disturbed, perturbed, all that. Well, I had a talk with Mr. Yashwant Kumar, police officer, yesterday. Some of you have heard him. The technology has so improved that even the place from where the WhatsApp message is sent or the email is sent can also be known. So therefore, this is a process by which, whether he really absconded, I may claim I have committed an offence in Bangalore. When people say, well, you did this, you absconded, you are not found at Bangalore at all. No, I still was in Bangalore. See, I have sent number of messages. During the course of investigation, it is possible to find out whether those messages were were sent by me from Bangalore or elsewhere. Mail was sent by me from elsewhere. So this is a content subsequent. Then, please go to section 8 of BSA. Things said or done by conspirator in reference to common design. This is corresponding to section 10 of IEA. In cases of conspiracy, again, most of these cases are in respect of circumstantial evidence cases, where there is a reasonable ground to believe that two or more persons have conspired together to commit an offence or actionable wrong. Anything said or done or written by any one of such persons in reference to their common intention, after the time when such intention was first entertained by any one of them, is a relevant fact as against each of the persons believed to be so conspiring, as well for the purpose of proving the existence of the conspiracy, as for the purpose of showing that any such person is a party to it. It is highly difficult for an investigating officer to place direct evidence of conspiracy. Obviously, it will be a circumstantial evidence. Two or four persons are seen at some place planning to go there. Now, of course, they may not really meet at a place. They may communicate through mails. They may communicate through WhatsApp messages. They may communicate through SMS. They may communicate through phone calls. You meet at a particular place. Now it is possible through the technology to see from where the call was sent, to whom it was, how it was sent. All those things are possible. It is in this context, having regard to the nature of crimes that we are seeing, we have our friend Mr. Sudhindranath in the commercial court. You must have seen in the civil matters, all documents are bare, is full of emails only, right? Except the joint development agreement. The rest of the documents are all emails, right? He would have sent it, he would have replied, that email trail is sent. It's a big problem. That's how things are going on now. So this is the situation where we are placed. Fortunately, I have retired. You are there. You have to deal with these things. Of course, I am also dealing with them to the best of my ability in the arbitration, with a strong hope that one of our district judges will not set aside the award. Of course, you are free to do it. Then, please go to section 2E of BSA. 2E of BSE. Evidence. 2E. Evidence means and includes subsection 1, I am leaving, you know it. Subsection or subclass 2. All documents, including electronic or digital records, produced for the inspection of the court, and such documents are called documentary evidence. So there is an insertion in the new BSA. This is also covered here. Then have a look at section 19 of BSA, corresponding to 21 of IEA, that is admissions. More in the context of a civil case. Twenty-one of IEA corresponding to 19 of BSA. Admissions are relevant and may be proved as against the person who makes them or is representative in interest, but they cannot be proved by or on behalf of the person who makes them or by his representative in interest, except in the following cases. Let us not worry about those things. Now, a suit for recovery of rent is filed by the landlord against the tenant. The defendant either denies that he is a tenant or pleads discharge and says that I have paid the entire rent. Some such stand is taken. Before the suit is filed or the matter reaches the court, a mail or a WhatsApp message or SMS is sent, not giving so many details about it. ಒಂದು ಸ್ವಲ್ಪ ತೊಂದರೆಯಲ್ಲಿದ್ದೀನಿ, ಒಂದು 15 ತಾಯಿರಿ ಕೊಡ್ತೀನಿ. No details. Whether it is rent or anything, nothing is there. I am not telling it is an acknowledgement under section 18. It's a different aspect of the matter. Now the landlord has saved that message. In the written statement, he has denied that anything is due, he is not a tenant and all that. Now when that that defendant is in the witness box, the lawyer for the plaintiff confronts that message. This is your cell number. You are on WhatsApp. You are in the habit of sending messages. He may deny or admit and all that. Well, this is this message. You have sent it. He must have some explanation for that. It is not in respect of the rent that I have sent this message. There are some other thing. He himself wanted me to lend some money. I said, wait for 15 days, I will thereafter lend. Whether that explanation is true or not is a different aspect of the matter. It might amount to an admission if the defendant is unable to show that statement which he says, give me some time, I will pay, is really not something about which it was something else. It will be a relevant piece of evidence. These things are likely to happen because there is no practice of writing letters and all that these days. So it is here these things are bound to be of some use to us. Then go to 26 of BSc. (26) corresponds to section 32. 32, many may be under the impression that it is confined only to dying declaration. Though in the normal course we are making use of 32 only for dying declaration, there are several things covered by section 32 of the Evidence Act. Even in respect of a civil case, it is quite possible. I will just read one such illustration there. Of course, dying declaration, all of you know it. I'll just refer to one illustration, one clause here. Kindly go to 26E, corresponding to 32E of the Indian Evidence Act. Before that, let me see. Statements written or verbal of relevant facts made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without an amount of delay or expense, which under the circumstances of the case appears to the court unreasonable, are themselves relevant in the following cases, namely. All of you know that there is an exception to the rule against hearsay, because unless a witness is cross-examined, his evidence cannot be taken. These kinds of persons are not available. I have told our young brothers and sisters 3 A's. A person should be alive, or should be available, or should be able to give evidence. He is alive, but he is not able, physically unable, he can't come at all. He is struck with paralysis, he can't move. He is alive, he is able but not available. We have many who are not available these days. So therefore, these are situations where some statement made by him can be read in evidence without he being subjected to cross-examination. All of us are familiar with dying declaration. No problem with that. Now, when the statement relates to the existence of any relationship by blood, marriage or adoption, in some document at one point of time, a statement is made, in ನನ್ನ ದತ್ತುಪುತ್ರಿಯಾದ ನನ್ನ ಮೊದಲನೇ ಮಗನಿಗೆ ಮಕ್ಕಳಿಲ್ಲದಿದ್ದರಿಂದ ಇಂಥವರನ್ನು ಒಂದು ದತ್ತು ಸ್ವೀಕಾರ ಮಾಡಿದ್ದರಿಂದ, at some undisputed point of time a statement is made. Maybe these days I may type it on my laptop and say, for some reason I may say something, write a letter or put it for my own reference or whatever it is, so and so. At one point of time it is likely to be of some use. At an undisputed point of time, I have recognized one as my adopted child, I have recognized a woman as my legally wedded wife, I have recognized a person or somebody else by blood, marriage or adoption. Then, F, when the statement relates to the existence of any relationship by blood, marriage or adoption between the person deceased and is made in any will or deed referring to the affairs of the family to which any such deceased person belonged. See, we have become so tech-savvy, many personal details are also saved, right? For the benefit of our children, we may put a genealogy there of our family in the pedigree, we may keep it, saying that she is my mother, he is my grandmother, so and so is my grandfather, forefather and all that. See, because these are times where the younger people may not be knowing the names of their grandfathers and grandmothers, because the situation is such. I am not finding fault with anybody. We have reached that situation. Therefore, somebody needs to put it. It is quite possible. Whether it is true or not, whether that by itself is a proof, all those things will come. It is a kind of relevant fact. Now, in the context of this digitalization and everything, these things also can be put in a system where when an occasion arises, somebody can definitely make use of it. Then, please go to section 28 in BSA, corresponding to section 34. entries in the books of account, including those maintained in an electronic form. There is an insertion here. Regularly kept in the course of business are relevant whenever they refer to a matter into which the court has to inquire, but such statements shall not alone be sufficient evidence to charge any person with liability. In the maiden days of the training program, both in the Judicial Academy and when the Directorate of Training was established, in fact, ours was the first batch to be trained by the Directorate of Training. It was established in 1985. There was a subject, suit on accounts and suit for accounts. No less a person than Honorable Justice M.N. Venkatachalaya used to deal with that subject. Suit on accounts and suit for accounts. Those of you whose memory is good may recall the provisions of Order 7, Rule 17 CPC. Suits on entries in the shop book. Well, youngsters might not have seen. You can go to some old shop in Avenue Road, ask him to show. There will be big ledgers with red color bound volumes. Right. Today he lends a sum of rupees 1 lakh to of those days only 2,000 rupees to Mr. Anand Shetty. To him about a person, he rents a Parameshwar Prasad now another 5,000 rupees. He goes on making that entry. Then he pays sum of rupees 1,000 on a particular day by way of repayment. All those, they are kept in the regular course. Of course, a self-interested testimony. What does the section say? Such entries alone shall not be sufficient evidence to charge any person with liability. So there should be corroborative evidence, which in the language of technical language is called evidence aliende, A-L-I-U-N-D. There must be, in addition to those entries, evidence aliende. Well, I want to bring to your notice two decisions of the Supreme Court in this regard, corresponding to section 34 of the Old Act. By and large, you find the same provision in the New Act, except that it is electronic forms is also included. 1998, Volume 3 SCC 410. 1998, Volume 3 SCC 410, CBI versus VC Shukla. A very important decision. In fact, no less a person than Kapil Sibal argued the matter. The Supreme Court did not accept it. It's a different aspect of the matter. How that account book should be. Should it be spirally bounded and all that? You may also read a later decision in 2017, 11 SCC 783. 2017, 11 SCC 783, Common Cause versus Union of India. Loose sheets of paper cannot be said to be these account books kept in the regular course and all that. Now it is possible. You have seen bank statements being generated. They are given for us in proceedings under 138, in number of civil cases, those bank statements. Here in this context, you may also refer to the Bankers' Book Evidence Act. You have heard Mr. Madhukar Deshpande. I believe he has touched upon 65B of the Evidence Act corresponding to some section here. Now, please have a look at the Bankers' Book Evidence Act, which also came to be amended in view of certain provisions of the Information Technology Act. Section 2 capital A of the Bankers' Book Evidence Act, this 2A came to be inserted by Act number 21 of 2000, that is when the Information Technology Act of 2000 was enacted. Conditions in the printout. A printout of entry or a copy of printout referred to in subsection 8 of section 2. What is that 2.8? 2.8. Certified copy means when the books of a bank are maintained in a written form, a copy of any entry. 8b. consists of printouts of data stored in a floppy disk, tape, or any other electromagnetic data storage device, a printout of such entry or a copy, etc. Then 8C, printout of any entry in the books of a bank stored in a microfilm, magnetic tape, etc. So, conditions in the printout. A printout of entry or a copy of printout referred to in subsection 8 of section 8 shall be accompanied by the following, namely. So, it is not just 65B, something else. A certificate to the effect that it is a printout of such entry or a copy of such printout by the principal accountant or branch manager. And B, a certificate by a person in charge of the computer system containing a brief description of the computer system and the particulars. A to L are the particulars. Then a further certificate from the person in charge of the computer system to the effect that to the best of his knowledge and belief such computer system operated properly at the material time. And therefore, if it is a statement of a bank relied upon in a civil case or in a criminal case under 138 and other things, please ensure yourself that the certificate is in accordance with Section 2A of the Bankers' Book Evidence Act. Then, please go to Section 29. An entry in any public or other official book, register, or a record or an electronic record. So, there is an insertion in this BSA stating a fact in issue, a relevant fact and made by a public servant in the discharge of his official duty, birth register, death register, marriage register, several other registers, mutation register, revenue registers, everything is digitalized there. Well, we will have to accept them now. Then, 32. Relevancy of statements as to any law contained in law books, including electronic or digital form. When the court has to form an opinion as to a law of any country, any statement of such law contained in a book purporting to be printed or published, including in electric or digital form under the authority of the government of such country, and to contain any such law and any report of a ruling of the court of such country contained in a book, including in electronic or digital form purporting to be a report of such rulings, is relevant. Then 33, corresponding to 39 of Indian Evidence Act. How much of the statement is to be proved? When any statement of which evidence is given forms part of a longer statement or of a conversation or part of an isolated document, or is contained in a document which forms part of a book, or is contained in a part of electronic record, or of a connected series of letters or papers, evidence shall be given of so much and no more of the statement, conversation, document, electronic record, books or series of letters or papers as the court considers necessary. In fact, I have seen these days, I think that must have been your experience also, Mr. Surender. Now you see, these transactions, they go in large numbers to the extent of crores, right? Crimes are to that extent. Voluminous documents are there. Everything you find in the system. Now, instead of producing all that, they just produce a pen drive these days, is it? Sir, ತಾವು ಬೇಕಾದ್ರೆ ಅದನ್ನು ಓಪನ್ ಮಾಡ್ಕೊಂಡು ನೋಡ್ಕೊಳ್ಳಿ ಸರ್, I don't want to burden the record by producing the whole of the record. Probably they also know that all of that may not be really relevant for the case. So, these are certain things which we need to keep ourselves abreast of in view of certain amendments brought to the, not amendments, it's a new law as such. The new law has taken care of this. Then we will go to 39. Opinion of experts, because all these things are contained in the part relating to relevancy of facts also. Opinion of experts, corresponding to 45 with some changes here and there. 45 has only one section with number of illustrations and other things. This 39 corresponding to 45 is divided into two subsections, 1 and 2. 39.1 is verbatim a reproduction of 45 as it exists. 39.2 is a reproduction of 45A of the Indian Evidence Act. See, what has been done in BSA is those A, B, C, capital A, B, C, D, they have all been shown as a subsection, or they have been given some numbers, A, B, C, D are excluded. Here and there is some change. So now that 45 capital A of the Indian Evidence Act finds a place as subsection 2 of 39, rightly, because it has to be read immediately after that. When in any proceeding the court has to form an opinion on any matter relating to any information transmitted or stored in any computer resource or any other electronic or digital form, the opinion of the examiner of electronic evidence referred to in section 79 capital A of the Information Technology Act is a relevant fact. For the purposes of this subsection, an examiner of electronic evidence shall be an expert. What is this section 79A of the Information Technology Act? 79 capital A. There is only one section in the entire chapter, chapter 12A of the Information Technology Act, 79A. The central government may, for the purposes of providing expert opinion on electronic form evidence before any court or other authority, specify by notification in the official gazette any department, body or agency of the central government or a state government as an examiner of electronic evidence. For the purpose of this section, electronic form evidence means any information of probative value that is either stored or transmitted in electronic form and includes computer evidence, digital audio, digital video, cell phones, digital fax machines, etc. So you can rely upon that. Then you may go to section 41, subsection 2. 41, opinion as to handwriting and signature. 47, subsection 2 is a reproduction of 47 capital A of the Indian Evidence Act. 47.2 corresponds to 47A. My suggestion to the young judicial officers is, if you have your own book, not the book of the academy, of course I think the association has given you that book, right, not just as a life estate to keep it for yourself. So therefore, if it is your own book, you can make a note of the provisions of the old enactments also, so that it will be easy. That comparative table is given every time. A comparative table ಯಾವ ಪೇಜಲ್ಲಿ ಅಂತ ಹುಡುಕತ್ತೆ 5 ನಿಮಿಷ ಆಗುತ್ತೆ. ಬುತ್ತಲ್ಲೇ ಇದೆ, ಕೆಳಗಡೆ ಕೊಟ್ಟಿದ್ರೆ ಒಳ್ಳೆಯದಾಯಿತು. ಇಲ್ಲದಿದ್ದರೆ ಯು ಬೆಟರ್ ಮೇಕ್ ಎ ನೋಟ್ ಆಫ್ ಇಟ್ ಇನ್ ದಿ ಮಾರ್ಜಿನ್ ವಿಚ್ ಐ ಡಿಡ್ ಇಟ್. ಅದೇ ರೀತಿ ಹಳೆ ಪುಸ್ತಕದಲ್ಲೂ ಹೊಸದು ಯಾವುದು ನೋಟ್ ಮಾಡ್ಕೊಂಬಿಡಿ, ಈಸಿ ಆಗುತ್ತೆ. ಬಿಕಾಸ್ ಇನ್ ಫ್ಯಾಕ್ಟ್ somebody said, not proper to mention the name here, somebody said recently, I just was watching some video, some Supreme Court advocate, when he was told to speak about these new laws, so goodbye to Indian Evidence Act, he said, goodbye until we meet next. Because the provisions say that in respect of pending matters and all that, those things would still remain. And at least as far as the Evidence Act is concerned, I repeatedly tell, there is not much of a change at all. ಏನಂಥದ್ದೇನೂ ಆಗಿಲ್ಲ. ಒಂದೇ ಒಂದು ಸೆಕ್ಷನ್ ಇದೆ, ಅದನ್ನು ಹೇಳ್ತೀನಿ ನಂತರ. ಒಂದು ಸ್ವಲ್ಪ ಕೆಲವು ಒಂಚೂರು ಅರ್ಥ ಬರೋ ಹಾಗೆ ಒಂದೆರಡು ಇದೆ, ಅದನ್ನು ದಟ್ ಐ ವಿಲ್ ಟೆಲ್ ಯು ಅಟ್ ದಿ ಎಂಡ್. ಸೊ ನೌ ಬೆಟರ್ ಯು ಮೇಕ್ ಎ ನೋಟ್ ಆಫ್ ಇಟ್, ಬಿಕಾಸ್ ಯು ಕಾಂಟ್ ಅಫೋರ್ಡ್ ಟು ಲೂಸ್ ಟ್ರ್ಯಾಕ್ ಆಫ್. ಆ್ಯಂಡ್ ಫಾರ್ ಯಂಗ್ಸ್ಟರ್ಸ್ ಇಸ್ ಅನ್ ಅಡ್ವಾಂಟೇಜ್, ಬಿಕಾಸ್ ಯು ಮೆ ನಾಟ್ ಬಿ ಫೆಮಿಲಿಯರ್ ವಿತ್ ದಿ ಪ್ರಾವಿಷನ್ಸ್ ಇನ್ ದಿ ಓಲ್ಡ್ ಎನಾಕ್ಟ್ಮೆಂಟ್ಸ್. ನಮಗೇನಾಗಿದೆ, ಓಲ್ಡ್ ಎನಾಕ್ಟ್ಮೆಂಟ್ಸ್ ಸೆಕ್ಷನ್ಸ್ ತಲೆಯಲ್ಲಿ ಇರೋದ್ರಿಂದ some of you youngsters credit me with good memory, but the problem for me is I am not able to remember these new provisions. ಪದೇ ಪದೇ ಎಷ್ಟು ಸರ್ತಿ ನೋಡಿದ್ರು ಕೂಡ ಇಲ್ಲೋ ಸರ್ತಿ ಅದು ಪ್ರಾವಿಷನ್ಗೆ ಗೊತ್ತಾದಲ್ಲಿ ಆಗ್ತಾ ಇದೆ. Now 47A, when the court has to form an opinion as to the electronic signature of any person, the opinion of the certifying authority which has issued the electronic signature certificate is a relevant fact. The certifying authority is not defined in the BSA. But there is one section there which says expressions which are not defined in this enactment shall have the same meaning as given in the other enactments and the Information Technology Act. That also you will find. Please go to subsection 2 of section 2. Words and expressions used herein and not defined, but defined in the Information Technology Act, the Bharatiya Nagarika Surashya Sanhita and the Bharatiya Nyaya Sanhita shall have the same meanings as assigned to them in the said Act and Sanhitas. So therefore, this word you will find it in capitals, you see. Therefore, obviously, it refers to a designated authority which has issued. So what is this certifying authority? You find it in section Section 2G of the Information Technology Act defines that. Certifying authority means a person who has been granted a license to issue a electronic signature certificate under Section 24. So therefore, if it is that certifying authority who has given that opinion, it would be a relevant piece of evidence. Then this primary evidence, it is in Section 57. Well, up to explanation 3, it is a reiteration of what is found in IEA. 4 to 7 are insertions. I think Mr. Madhukar Deshpande has taken you through them. I avoid it. Then, secondary evidence, section 58, corresponding to section 63. Here also, I think almost a repetition of the same thing. Then 59, proof of document, 60, when secondary evidence can be given. New section 61, electronic or digital record. Nothing in this adhiniyama shall apply to deny the admissibility. Nothing in this adhiniyama shall apply to deny the admissibility of any electronic or digital record in the evidence on the ground that it is an electronic or digital record, and such record shall, subject to section 63, 63 is corresponding to 65B, shall, subject to section 63, have the same legal effect, validity and enforceability as other document. Of course, even without this section, it would have been the position. Maybe the parliamentarians wanted to be very clear because it is an electronic record and all that. Well, they have made it very clear that it is as much a valid document as a hard copy or a physical document is, subject to the condition that a certificate as contemplated in 63 corresponding to 65B is given. Then I am also asked to speak about oral evidence. There is not much there. 54, proof of facts by oral evidence, all facts except the contents. 55, oral evidence to be direct. There is nothing there, no amendments and all that. Now when it comes to the role of a trial judge, by and large, there is no particular provision as such either in the Indian Evidence Act or in this BSA, but you find a good number of provisions in that last part, that is production and effect of evidence. Have a look at chapter 10 in BSA, examination of witnesses, 140. Well, we have some control over the manner in which, rather the order in which the witnesses could be examined. We can insist upon it. In fact, in a civil case, Order 18 requires that the plaintiff or the defendant should examine himself. There is also an exception. If for some reason A witness needs to be examined with the permission of the court and all that. By and large, in criminal cases, the pattern that is followed is to go by the serial numbers given in the charge sheet unless we find. Then 141, judge has to decide the admissibility of evidence. So these are all things about which you have some control. Then 142, examination of witnesses. I think juniors have heard me at great length very recently. Seniors know all these things. Examination chiefu, tarasu ಅವೆಲ್ಲ ಹೇಳೋ ಅಗತ್ಯ ನಿಮಗೇನಿಲ್ಲ. Then 144, cross-examination of persons called to produce a document, witness to character, leading questions, then evidence as to cross-examination as to previous statements. Now, 149, I may need a little reference. Questions lawful in cross-examination, provided that in a prosecution for an offence under 64, 65, 66, 67, 68, 69, 70 or 71 of Bharatiya Nyaya Samhita, they relate to the sexual offences, outrage in the modesty of woman, rape and all that, where the question of consent is an issue, it shall not be permissible to adduce evidence or to put questions in the cross-examination of the victim as to the general immoral character or previous sexual experience of such victim with any person for proving such consent or the quality of consent. I think barring a few of the judicial officers recruited up to 2003, others would have seen we had this 155(4) of the Evidence Act. In a case of prosecution for rape, the prosecutrix could be questioned with regard to her character. Despite the existence of such a provision, the Supreme Court in a host of decisions said that is totally impermissible. A little delicate to tell me, the Supreme Court said, well, even a woman who is known for other purposes, she can also afford to refuse access to a man. She has that right, that control over her body autonomy. No questions were permitted. Subsection 4 came to be deleted by some amendment. Youngsters were not there, and I think some district judges of 97, 98, 95 were also here, not earlier to 95. I see them. It's the only thing I can remember which batch you were. So, ಯಾವುದು ಅಲ್ಲ ಕರೆಕ್ಟ್ ಅಲ್ಲ 95, 97, 98 ಇದಿರಲ್ಲ, 95 ಇದ್ದಾರೆ, 97 ಇದ್ದಾರೆ, 98, 99, 2001, 2003 ಎಲ್ಲ ಇದಿರಲ್ಲ. 2004 ಅತಡೆ ಮೇಲೆ ಇದ್ದಾರೆ ಆಳ್ವಾರು, ಇಲ್ಲೂ ಒಬ್ಬರು ಇಬ್ಬರು ಇರ್ಬೋದು ಅಂತ ಅನಿಸುತ್ತೆ. ಆಲ್ ರೈಟ್. So that was the provision now. No such questions can be asked about that. Then 153, procedure of court in case of question being asked without reasonable grounds. Some imputation regarding character and other things. No basis, simply putting you are a fraud and all that. You see, I recollect a case. See, what happened in that case was a suit was for permanent injunction. As usual, the defendant said something in the written statement, plaintiff is in the habit of filing such frivolous suits only to make an unlawful gain. So, because it said it is a written statement where something is put in writing, it amounts to libel, plaintiff sued him for damages for defamation. Fortunately for the plaintiff and unfortunately for the defendant, that suit for permanent injunction was decreed. So it would no longer be said to be a frivolous suit. So I think even when this suit for permanent injunction was pending, the plaintiff in that suit for permanent injunction filed a suit for damages for defamation. I don't remember whether the trial court had dismissed the suit or decreed the suit. The matter came up in appeal when I was with the principal district judge in the Bengaluru rural court here. Some youngster from National Law School with good English brought Halsbury's Laws of England, Law of Torts by and all that, went on reading some passages. On the other hand, a person from some rural part, Nelmandla and other things, not all that good in English, he gave a direct decision of the Karnataka High Court. Am I bound by the decision of the Karnataka High Court or by that brilliant English exposition in Halsbury's? It was a direct decision. A similar case where in a suit for injunction, defendant had said that to make an unlawful gain, the plaintiff had filed that suit and he was in the habit of filing such suits. The Honorable High Court said it would clearly amount to defamation, and of course it quantified the damages. So therefore these are situations where without any basis these questions are put. Then indecent and scandalous questions, of course I have retired about 8 years back. Of course situation had by then improved. Maybe those of you who are in charge of the Potso court know, maybe the lawyers are also now sensitized, I believe. They are not going astray. I believe so. If not, it is time for you to see that they are brought to book. Then questions intended to insult are, of course, there is some contradiction in the provisions themselves. Questions can be put to see what his position in life is, to shake his credit, to shake his character and all that. Another provision saying something touching upon the character. In fact, I had a matter where a question was asked by a lawyer. The other lawyer said this is actually character assassination. That lawyer humorous, your client has no character at all for me to assassinate. So, well, those things would happen. So we'll have to take a reason. Ellana balance ಮಾಡಿ ಯಾವ ಸೆಕ್ಷನ್ ಕೇಳಿದ್ರೆ ರೆಲೆವೆಂಟು ಅಂತ ನಾವು ಮಾಡೋಕ್ಕಾಗಲ್ಲ. By and large, we should have a wholesale view of the entire enactment and draw a line and do it, because when every question is asked, we can't go on searching under which section of the Evidence Act it is relevant, which is excluded. By experience, we would be able to know it. Because the Indian Evidence Act 1872, it served us for a very good long time. It is still going to serve. It is not that from 1/7/2024 we can afford to ignore that. Then 157, I would like to spend some time on this. This is corresponding to 154 of Indian Evidence Act. Well, kindly excuse me for a moment. I told it to the public prosecutors also yesterday. Please do not mistake me. I am sure that no one in this group is doing it. If for some reason not knowing the legal position in that particularly youngsters, please do this. You see, 154, though we say hostile, the word hostile is not here. Cross-examining one's own witness. It is not just confined only to a criminal case. Even in a civil case that could be done, but very rarely it happens. Subsection 2 is corresponding to 154(2) of the Indian Evidence Act. Subsection 2 came to be inserted in the Indian Evidence Act by an amendment brought in the year 2005, Act number 2 of 2006. What does subsection 2 tell us? Nothing in this section shall disentitle the person so permitted under subsection 1 to rely on any part of the evidence of such witness. Most of the district judges here know that even before subsection 2 came to be inserted in section 154 of the Evidence Act by this 2006 amendment, the Supreme Court in a host of decisions held that the evidence of a hostile witness is not completely effaced from the records. I have on good number of occasions in the academy told the judicial officers by giving examples. See, what is happening is this. Kindly excuse me, please don't mistake me. Because of the pressure of quota or not being able to comprehend these things, some of us, at least what we have done or might have done is this. In a criminal case, the witness turns hostile. Prosecution wants to have an easy go and he says, ಪೊಲೀಸ್ನವ್ರ ಮುಂದೆ ಈ ಥರ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದರಿಂದ ಓದ್ಬಿಡ್ತಾರೆ, ಸುಳ್ಳು ಅಂತಾನೆ. ಈಗ ಓದಿ ಹೇಳಿದ ನಿಶಾನೆ ಪಿ ಎಂಟರಂತೆ ನಾನು ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಎನ್ನುವುದು ಸರಿಯಲ್ಲ, ನಾವು ಬರ್ಕೊಂಡು ಕೂತ್ಬಿಟ್ಟಿದ್ದೀವಿ. ಹೌದಾ? ಇನ್ಫ್ಯಾಕ್ಟ್ ಒನ್ ಆಫ್ ದಿ ಆನರಬಲ್ ಜಡ್ಜಸ್ ವಾಸ್ ಅ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಒನ್ಸ್ ಟೋಲ್ಡ್ ಮೀ, ಅವ್ರೇನು ಸ್ಟೇಟ್ಮೆಂಟ್ ಪ್ರೂವ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಫ್ಯಾಕ್ಟ್ ಪ್ರೂವ್ ಮಾಡ್ತಿದ್ದಾರೆ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಅಂತ. See, the correct way of cross-examining the hostile witness is to ಒಂದೊಂದು ಓದೋದಲ್ಲ. ನೀವಲ್ಲಿದ್ದಿರಿ, ನಿಮ್ಮ ಸಮಶ್ರಮ ಆಕ್ಸಿಡೆಂಟ್ ಆಯಿತು, ಅವನು ವೇಗವಾಗಿ ಬಂದ, ಹೊಡೆದಿದ್ದು ನೋಡಿದ್ರಿ, ನೀವೇ ಬಿಡಿಸಿದ್ರಿ, ಅವನ ರಕ್ತ ಬಂದಿತ್ತು ಅಂತ. ಇಟ್ ಮಸ್ಟ್ ಹ್ಯಾವ್ ಬೀನ್ ದಿ ಎಕ್ಸ್ಪೀರಿಯನ್ಸ್ ಆಫ್ ಅಟ್ಲೀಸ್ಟ್ ದಿ ಸೆಷನ್ಸ್ ಜಡ್ಜಸ್ when a well-meaning public prosecutor, having a bit of knowledge, cross-examines a hostile witness, he is still able to bring out something. I have seen voice ಮೈಕ್ ಆಫ್ ಆಗಿಲ್ಲ, ನಾನು ಹಿಂದುತ್ವದೆ. Now, particularly these major witnesses, standard form of hostility, ಪೊಲೀಸ್ ಸ್ಟೇಷನಲ್ಲಿ ಸೈನ್ ಮಾಡಿದೆ, ಆಲ್ ರೈಟ್, ಹಾಸ್ಟೈಲ್ ಮಾಡ್ತೀವಿ. ಸ್ವಲ್ಪ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಇಂಟ್ರೆಸ್ಟ್ ಇಟ್ಕೊಂಡು ನಾವು ಕೂಡ ಅವ್ರು ಎಂಕರೇಜ್ ಮಾಡಿದ್ರೆ, ಅದು ಒಂದು ದಿವಸಕ್ಕೆ 20 ವಿಟ್ನೆಸ್ ನಾವು ಮಾಡಲೇಬೇಕು, ನಾವು ನಮ್ಮ ನಿಯಮ ಹಾಕ್ಕೊಳ್ಳೋದು ಬೇಡ. ಅದು ಮಾಡಿದ್ರೆ ಸ್ವಲ್ಪ ಸೀರಿಯಸ್ ಆಗಿ ಕ್ರಾಸೆಡ್, ಸರ್ ಪೊಲೀಸ್ನವ್ರು ಬಂದಿದ್ದು ನಿಜ ಸರ್, ಇವನು ಅಲ್ಲಿದ್ದ, ಮುಂದೇನಾಯಿತು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಡಸ್ ನಾಟ್ ದಟ್ ಪಾರ್ಟ್ ಆಫ್ ದಿ ಎವಿಡೆನ್ಸ್ corroborate the evidence of the investigating officer and the other punch witness that the police had come did something? He might not have supported the prosecution in entirety, but does not his evidence come to the aid of the court and the prosecution to show that something really happened at this spot? Now, in the statement under 161, corresponding section is 180 or something in Bharatiya Nagarika Surashcha Samhita, he has made a statement to the effect that he has seen the incident, an eyewitness. Right. For some good reason or bad reason, he turns hostile. Totally hostile, nothing happened. So we are happy in retarding one's full sentence saying the police store ಮುಂದೆ ನಿಶಾನೆ ಪಿ ಎಂಟರ್ ಅಂತ ಹೇಳಿಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ ಎಲ್ಲೂ ಸುಳ್ಳು, ಪಿ ಇಸ್ ಆಲ್ಸೋ, ಸರ್ ನಾನು ಪಕ್ಕದ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ತೀನಿ ಸರ್, ನೀವು ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಅವ್ರು ಹೊಟ್ಟೋಗ್ತಾರೆ, ಹರಡನ್ನು ತೊಗೊಳ್ಳಿ, ಆಲ್ ರೈಟ್ ಫೈನ್, ನೋ ಪ್ರಾಬ್ಲಮ್ ವಿತ್ ದಟ್. ನೌ ಸಪೋಸಿಂಗ್ ಇಫ್ ಈ ಸೀರಿಯಸ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ಡ್, ಇಟ್ ಟರ್ನ್ಸ್ ಔಟ್, ಸರ್ ನಾನು ಅಲ್ಲಿದ್ದಿದ್ದು ನಿಜ, ಏನೋ ಗಲಾಟೆ ಆಗ್ತಿತ್ತು, ಇವನಲ್ಲಿದ್ದಿದ್ದು ನಾನು ನೋಡಲಿಲ್ಲ, ಅಥವಾ ಅವ್ನು ಓಡೋದ ಸರ್, ನನ್ನ ಮುಂದೆ ಅವ್ನು ಹೊಡೆದಿಲ್ಲ, ಎಷ್ಟು ಪ್ರೂವ್ ಆಯ್ತು ಅಲ್ಲಿ? ಒಂದು ಗಲಾಟೆ ಆಗಿದ್ದು ಪ್ರೂವ್ ಆಯಿತು, ಆರೋಪಿಯಲ್ಲಿ ಇದ್ದು ಓಡೋಗಿದ್ದು ಪ್ರೂವ್ ಆಯಿತು, ಈ ವಿಕ್ಟಿಮ್ನಲ್ಲಿ ಬಿದ್ದಿದ್ದು ಪ್ರೂವ್ ಆಯಿತು, ಅವನ ರಕ್ತ ಬಂದಿದ್ದು ಪ್ರೂವ್ ಆಯಿತು, ಈ ವ್ಯಕ್ತಿ ಅವನನ್ನೆಲ್ಲ ಆಸ್ಪತ್ರೆ ತಗೊಂಡೋಗಿದ್ದು ಪ್ರೂವ್ ಆಯಿತು. ಹೌದಾ? ಸೊ ದೇರ್ ಫೋರ್ encourage those public prosecutors who really mean business, who are really honest, please do that. I tell you, I have been telling this to our officers. When the old building was still there, around 4 p.m. or 4:30, I was in the library of that old building. An officer who had completed the 3rd phase of training also came to me. ಸರ್, ಇದೊಂದು ಕೇಸಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದೀನಿ, ಸ್ವಲ್ಪ ಸರಿಯಾಗಿದೆಯಾ ನೋಡಿ ಸರ್ ಅಂತಂದರು. ವಾಟ್ ಹಿ ಹ್ಯಾಡ್ ಡನ್ ವಾಸ್, ವೆನ್ ದಿ ಪ್ರಾಸಿಕ್ಯೂಟರ್ ಸಾಟ್ ಪರ್ಮಿಷನ್ ಟು ಟ್ರೀಟ್ ಹಿಮ್ ಹಾಸ್ಟೈಲ್, ಪರ್ಮಿಟೆಡ್. ಈಗ ಓದಿ ಹೇಳಿದ ಹೇಳಿಕೆ ಸುಳ್ಳು. ಯಾಕೆ? ಇಲ್ಲ ಸರ್, ಪ್ರಾಸಿಕ್ಯೂಟರ್ ನಾನು ಡೀಟೇಲಾಗಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ನಾನೇನೇ ಅವ್ರಿಗೆ ಯಾಕೆ ಹಾಸ್ಟೈಲ್ ಆಗಿರೋ ಬ್ಯಾಡ್ರಿ ಮಾಡಿದೆ ಅಂದೆ. ಆಯಿತು, ಈಗಲಾರು ನಿಮ್ಗೆ ಏನೋ ಒಂದು ಸ್ವಲ್ಪ ನೀವು ಮಾಡಿರೋದು ತಪ್ಪು ಅಂತ ಅನಿಸಿದೆಯಲ್ಲ, ಐ ಆಮ್ ಹ್ಯಾಪಿ. ಇಫ್ ಯು ಹ್ಯಾಡ್ ಪುಟ್ ದಿ ಸೇಮ್ ಡೌಟ್ yesterday when the training was still there, I would have told the same thing to all the officers. Now of course I have been telling this to all the officers. ಸೊ ಆ ಶಾರ್ಟ್ಕಟ್ ನಾವು ಮಾಡಿದಾಗ ಏನಾಗುತ್ತೆ ಅಂದರೆ, ಕೆಲವು ಸರ್ತಿ ಪ್ರಾಬ್ಲಮ್ ಆಗಿ ಹೋಗುತ್ತೆ. ಸಮ್ ಪಾರ್ಟ್ ಆಫ್ ಇಟ್ ವಿಲ್ ಸ್ಟಿಲ್ ಬಿ ಅವೈಲಬಲ್ ಫಾರ್ ಅಸ್ ಫಾರ್ ಕನ್ಸಿಡ್ರೇಷನ್. ಪ್ಲೀಸ್ ಡೋಂಟ್ ಟ್ರೀಟ್ ಮಿ ಹಾಸ್ಟೈಲ್ ಫಾರ್ ಮೇಕಿಂಗ್ ದಿಸ್ ಸ್ಟೇಟ್ಮೆಂಟ್. ಐ ಹ್ಯಾವ್ ನಥಿಂಗ್ ಅಗೇನ್ಸ್ಟ್. ಐ ಆಮ್ ಕಾನ್ಫಿಡೆಂಟ್ ದಟ್ ನೋ ಒನ್ ಆಫ್ ಯು ಇನ್ ದಿಸ್ ಗ್ರೂಪ್ ಈಸ್ ಆಫ್ ದಟ್ mold. But for some purpose I have seen this is happening. This is not the way a cross-examination in respect of a hostile witness can go on. And then we will just go to the other sections, impeach in the credit of a witness. Now, with regard to section 160, 157. Well, this is more particularly for the sessions judges here. Not that it has no applicability to magistrates, but the situations for the sessions judges would be more here. In order to corroborate the testimony of a witness, any former statement made by such witness relating to the same fact at or about the time when the fact took place or before any authority legally competent to investigate the fact may be proved. Before that, I'm sorry, it is 159. When a witness whom, I'm sorry, it is 160. In order to corroborate the testimony of a witness, any former statement made by such witness. Now, we have got good number of decisions. I'm not referring to them because that's not the real life, but you see the statements under section 164 CRPC find out the corresponding provision in BNSS. One is a confession statement, I am not on that. The other is a statement of a witness recorded by a magistrate. We have been telling the post-war judges not to summon them unnecessarily because it is there. Section 80 of the Evidence Act says that everything stated therein is correct unless it is absolutely necessary. Now we have got good number of decisions for the proposition that the evidentiary value of the statement under 164 is no better than that of 161 with a rider. 161, as all of you know, I am referring to old sections. I am an old man, I am referring to old sections. 161, as all of you know, is only for purposes of contradiction, not for corroboration. 164, both for corroboration and contradiction. It could be marked in the chief examination also because it is a kind of corroboration. So, beyond that, then what is the advantage? The provisions of 164 would show that the magistrate who records the statement of the witness under, I am not referring to confession, that's not the junior's mistake, I am referring to the statement of a witness under 164. He needs to administer oath to the witness. Some evidence recording in the manner of a summons trial or something is stated there. So we have two statements on oath. One before the magistrate when he examined him under 164, another before the court where he gives a totally different version. Two irreconcilable statements. Well, he could be hauled up for perjury. Now, not that I am suggesting that you should haul up him for perjury, but there is that scope for that. Maybe some kind of a feeling, it is a statement made by me before the magistrate, let me not totally turn hostile. Something might morally infuse him. So it is perfectly a statement that could be done. Now, the police record the statement as a dying declaration. Fortunately, the man survives. Now it is not 161 because it is signed. It has been recorded as a dying declaration. Now the Supreme Court has said that statement which would have otherwise had the bar of 161, it ceases to be it is not a dying declaration because the man has survived. It could be taken as a statement under 159, a previous statement corroborating his oral testimony. I am sure that you have those decisions with you. Well, you may look to them. If you don't have it, at the end I will give it. Because I brought them to tell the public prosecutors, if you still want them. Refreshing memory, all that, you just need to refresh your memory of section 159 of the Old Act. All of you know it. Here, of course, these junior officers have some problem with these investigating officers. Lawyer says he can't look into the record. How can he say depose something without looking into the record? If he does not look into the record, tutored ಅಂತಂತಾರೆ. ಹೇಗೆ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಇವಾಗ ನೀವೇ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಮಾಡಿ ಎವಿಡೆನ್ಸ್ ಕೊಡಬೇಕು ಅಂತಾರೆ, ನೋಡದೆ ರೆಕಾರ್ಡ್ ನೋಡದೆ ಹೇಳೋಕ್ಕಾಗತ್ತಾ? ಸಿ ಇಫ್ ದಿ ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್ ಈಸ್ ಹಿಮ್ಸೆಲ್ಫ್ ಎ ವಿಕ್ಟಿಮ್, ಕೆಲವು ಸರ್ತಿ ಪೊಲೀಸ್ನವ್ರಿಗೆ ಹೊಡೆದಿರ್ತಾರೆ, ಅದು ಕರೆಕ್ಟು. ಬೇರೆದೊಂದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡೋದು ಯಾವತ್ತು FIR ರಿಜಿಸ್ಟರ್ ಮಾಡಿದೆ, ಯಾವತ್ತು FSL ಕಳಿಸ್ದೆ, ಯಾವತ್ತು ಯಾರು ಸ್ಟೇಟ್ಮೆಂಟ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದೆ ಅನ್ನೋದನ್ನು ನೋಡದೆ ಹೇಳೋಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲದೆ ಇರ್ತಕ್ಕಂಥದ್ದು. ಪ್ಲೀಸ್ ಸಿ that they are allowed to refresh their memory. Doctors are also allowed to refresh their memory. They can even refer to the professional treatise. Some leading criminal lawyer would have read some Modi's medical jurisprudence, something case and ready, he would have asked. ನಾನು ನೋಡಬೇಕು, ಇವಾಗ ನಮಗೂ ಯಾರಾದರೂ ಕೇಳಿದ್ರೆ ಮುಲ್ಲಾ ಸಿ ಪಿ ಸಿ ರಾಜ್ಯದಲ್ಲಿ ನೋಡದೆ ಹೇಳೋಕ್ಕಾಗುತ್ತಲ್ಲ ಅವು. ಡೆಫಿನೆಟ್ಲಿ ದಿ ಡಾಕ್ಟರ್, ವಿ ಕಾಂಟ್ ಎಕ್ಸ್ಪೆಕ್ಟ್ ದಿ ಡಾಕ್ಟರ್ ಟು know all those things. If he says, give me the book, I will explain it. It is perfectly permissible for you to do it. Now, one thing which is, there is that slight amendment here. Please go to section 168 of the new code, corresponding to 165. As all of you know, under 165 of Evidence Act, court has power to put irrelevant questions also. Now that is not there. If you want me to read 165 of the Indian Evidence Act, I will read it. First I am reading 165 the Indian Evidence Act. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any forum, at any time, of any witness or the parties about any fact relevant or irrelevant. So judge has the power under the Indian Evidence Act. I am deliberately using the present tense has, because Indian Evidence Act, it is still there, irrelevant. But here under 168, judge may, in order to discover or obtain proof of relevant facts, ask any question he considers necessary in any forum, at any time, of any witness or the parties about any fact, and may order the production of any document or thing, and neither the parties nor their representatives shall be entitled to make any objection to any such question or order. The word irrelevant is omitted. I only obvious, ಯಾಕೆಂದ್ರೆ ಅಲ್ಲಿ ರೆಲೆವೆಂಟ್ ಆರ್ ಇರಲೆವೆಂಟ್ ಅಂತಿತ್ತು, ಇಲ್ಲಿ ಎನಿ ಕ್ವೆಶ್ಚನ್ ಕುಡ್ ಬಿ ಡನ್. ಐ ಸ್ಟಿಲ್ ರಿಮೆಂಬರ್ it was on 27/9/99 I took charge of this academy as deputy director. It was the post of the cadre of a senior civil judge. 27/9/1999. On that very day, late Ram Jethmalani had come to the academy and spoke to the trainee judicial officers. Coming as it did from a person of his stature, I have accepted that to be the logic behind it. What he said was, when a question is put by a lawyer and the other lawyer says it is irrelevant, there is a third neutral person to say whether it is relevant or not, that is the judge. But when the judge puts a question and the lawyer says it is irrelevant, it is a very embarrassing thing. Judge putting a question, lawyer says irrelevant, the judge himself has to say whether it is relevant or irrelevant, and therefore the legislature took care to see that no objection shall be raised. But the legislature did not stop there. It said, but while writing judgment, please take into consideration the answers given to relevant facts only. That's what Ram Jethmalani said. As I said, coming the statement as it came from a person of his stature, I took it to be the correct position. I have not searched it. I have not looked it for corroboration also. I have accepted his statement at its face value. These are certain things which have been now, well, it may be a little beyond this subject, but yet I want to tell one thing. I have a recent decision also of the Karnataka High Court on this point. You see, of course, this is in the context of circumstantial evidence, but that would be applicable to cases of direct evidence also. That basic principle in a criminal case, charge should be proved beyond all reasonable doubt, fine. Now, proof beyond reasonable doubt, benefit of doubt, they all go together. What is it that has to be proved beyond reasonable doubt? Is it every circumstance in that chain of circumstances, or what is it? Or the participation or the involvement or of the accused? That is important. We have a good decision of the Supreme Court. Most of you may be knowing it. That is in AER 1963 Supreme Court 200. M.G. Agarwal versus State. M.G. Agarwal versus State. See, what the Supreme Court has said is, these basic facts, primary facts, will have to be proved by ordinary evidence. The prosecution need not prove the Mahajar beyond reasonable doubt. It need not prove the injuries beyond reasonable doubt. It need not prove the death beyond reasonable doubt. What is required to be proved beyond reasonable doubt is the involvement, the participation of the accused. It is there that concept of benefit of doubt comes. Because maybe for lack of clear understanding of these principles, we find in judgments evidence of PWT is not beyond reasonable doubt. His evidence does not disclose beyond reasonable doubt that the police came to this spot, drove the Mahajar recovery. That is not the way it is to be done. This judgment of the Supreme Court has been referred to and followed very recently by the Honorable High Court. It is directed to be reported. I have not checked whether it is reported. I will give you the case number and other details. It is directed to be reported. The date of the judgment is 27/9/2023. It's a judgment of a division bench. 27/9/2023. Criminal Appeal 870 of 2077. Criminal Appeal 870 of 2017. I do not know the subcategory. It is mentioned as A within brackets. I do not know what that A stands for. Huh? Oh, A for acquittal. Sorry for that. Criminal Appeal 870 of 2017. Yes, you are right, because the appellant is the state. State represented by Assistant Superintendent of Police Puttur versus Dr. Renuka Prasad and others. I repeat, Criminal Appeal 870 of 2017. Date of judgment is 27/9/2023. A judgment of a division bench. State represented by Puttur Police, Dr. Renuka Prasad and others. You are aware of it, okay. A fairly long judgment. I am not on the facts of that case. Yes, I have been convicted. Para 98 of the judgment. We digress for a moment. I am also digressing from subject. We digress for a moment to deal with the nature of evidence to be placed before the court whenever the prosecution has to prove the circumstances to establish its case. In this context, a decision of the Supreme Court in the case of M.G. Agarwal versus State of Maharashtra, AR 1963 Supreme Court, may be relied on. The following is the observation in para 18 which I read just now. That means, after extracting the relevant portion of the judgment of the Supreme Court, this is what the division bench says. That means, while appreciating evidence, it is not necessary that every circumstance is to be proved beyond reasonable doubt. Every circumstance need not be proved beyond reasonable doubt. Primary or basic evidence suffices, and it must be proved in the ordinary way, civil standard. That is why we are all district and sessions judges, civil judges and JBFCs. Primary or basic evidence suffices, and it must be proved in the ordinary way. We are compelled to make an observation here, and I am compelled to refer to this decision. while dealing with appeals either against acquittal or conviction judgments, we have seen some trial court judges referring to evidence of each witness and giving a finding whether the prosecution case is proved beyond reasonable doubt or not through that witness. This we opine a wrong method of appreciation of evidence. Only after collation and analysis of entire evidence, that is both oral and documentary, it must be examined whether overall inference leads to proof beyond reasonable doubt. If primary evidence in regard to one circumstance is not established, there is a break in the chain of circumstances, etc., then it refers to the other situations in this regard. This is all what I wanted to tell you. Thank you for giving me a patient hearing. If you have got any questions, you are free to ask. First, I would welcome questions from the junior officers. Any questions from the junior officers? Not necessarily confined to Bharatiya Sakshya Adhiniyama. Any questions? Preferably from junior officers. If you feel a little delicate to put the questions here, all right, I am available there. Or you can call me over phone if there is any problem, if there is any confusion. Please deal with these new enactments, particularly the Criminal Procedure Code, with an amount of confidence. Because I find with 167, I myself found it difficult to understand that section. I read it day before yesterday. Today while coming in the car, I read it. Now I have some fair idea of that. That some 40 days, initial 40 days, 90 days and all that. That a trial in absentia, I think Mr. Radhakrishna Holla would be dealing with it. In his absentia, it will not be proper for me to tell that. He will tell you. Because he has worked completely on the judicial side, elder to me in age, experience, 33 years, good at criminal law. He will tell you about all that in the afternoon. With all that, if any younger members of the judiciary, if you have got still any doubt about any of those things, you are free to call me. Maybe you have some reservations to ask questions because that is how we have grown. Maybe when the seniors are there, you hesitate to put questions and all that. I know all that. Because moreover, this looks like a function hall than a regular classroom. This is another, though otherwise it is file, ambience is good. Maybe you have that inhibition, no problem. You can call me later. To the best of my ability, I will be able to do it. As far as the penal code is concerned, it had been never my cup of tea and I have also not looked into it. Because in my opinion, it is not something about which a class needs to be told. As and when a case comes before us, we will have to analyze the section and see whether the ingredients are made out or not. I have a question to all of you, not to test you. I have seen some material being put, certainly don't mistake it me. Nani nimminda information bekagide. I did not get it in the new criminal procedure code. I have heard people telling they have seen some literature being found. Charge sheet has to be filed within 180 days. Day before yesterday also there was something there. I am not getting it anywhere in the new code. Can any one of you help me in finding out where the, because for further investigation some 90 days and other things. The impression appears to be that the charge sheet itself has to be filed in 180 days. I know that in POTSO and other things there is some provision saying within, seeing that nobody is telling that, I think that provision doesn't exist. ಎಲ್ಲಿದೆ 180 ಡೇಸ್ ಒಳಗೆ ಫೈನಲ್ ರಿಪೋರ್ಟ್ ಹಾಕಬೇಕು ನನಗಂತೂ ಸಿಕ್ಕಲಿಲ್ಲ. ಅದು ಎಲ್ಲಿ ಸಿಗುತ್ತೆ ಹೇಳಿ CRPC ಸ್ವಲ್ಪ ಪಾಯಿಂಟ್ ಔಟ್ ಮಾಡಿ. ಪ್ರೋಗ್ರೆಸ್ ಒಪ್ಕೊತೀನಿ, ಚಾರ್ಜ್ ಶೀಟೇ 180 ಡೇಸ್ ಒಳಗೆ ಹಾಕಬೇಕು ಅಂತ ಹೇಳಿ ಮೊನ್ನೇನೂ ಇಲ್ಲೇನೋ ಅದು ಪವರ್ ಪಾಯಿಂಟ್ ಪ್ರಾಜೆಕ್ಟಲ್ಲಿ ಅದೇನೋ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇತ್ತು, ಬೇರೆ ಅಲ್ಲಿ ಇಲ್ಲಿ ಬರ್ತಾ ಇರುತ್ತಲ್ಲ ಅದರಲ್ಲೆಲ್ಲ ಇತ್ತು. ಅದು ನನಗಂತೂ ಅದು ಸಿಗ್ತಾ ಇಲ್ಲ. Has anybody found that 180 days saying that is the limit within which the charge sheet has to be filed? I am not getting it. Please don't think that I am testing you. Certainly I am not aware, I didn't get it. If you get it, please tell me that. All right. Anyway, I will take it. Yes, any questions? All right, if there are no questions, thank you all. I know that I have slightly deviated because it was difficult for me to understand the title of the subject. New dimensions in assessing relevancy of evidence. I don't find any new dimension there. First, let us know the old manner of appreciating these things. Let us slowly progress. So, may I take it that we have nothing more? Because officers are used to listen to me even after 2 p.m., but today I am closing much before 2 p.m. Sometimes for some subjects, 2 hours was too long for me, so I used to manage with something else. For some subjects, 2 hours was insufficient. Today I have been able to manage it because I didn't find this. And moreover, it's a heterogeneous group consisting of senior officers and others. Shall we close or yes, Anand Shetty has something to contribute? 90 days ಅದೇನು ಕೊಟ್ಟಿದ್ದಾರೆ ಒರಿಜಿನಲ್ ರಿಪೋರ್ಟ್ಗೆ ಇದ್ದಾಗಿಲ್ಲ. Yes. Parameshwara Prasanna, you are also dealing with criminal cases or only civil there? Both. You were in Srirangpatna, to which place you moved now? Hubballi. ನೀವು ಸಿಂಧನೂರು. ನೀವೆಲ್ಲಿದ್ದೀರಿ? ನಿಮ್ಮ ಮನೆಯವರು? ಅಲ್ಲೇ, ಸರಿ. Yes, anything else? ಸ್ವಲ್ಪ ಲಿಂಕ್ ಹಿಡಿದೆ, ಸ್ವಲ್ಪ ಕೆಲವಿದೆ, ಇರಲೇಬೇಕಾಗುತ್ತೆ. ಬಟ್ ಎವಿಡೆನ್ಸ್ ಆ್ಯಕ್ಟ್ ಆ್ಯಸ್ ಸಚ್ ಏನಂಥದ್ದೇನು ಪ್ರಾಬ್ಲಮ್ ಆಗಿಲ್ಲ. ಅದು the saying goes that it's old wine in the new bottle or something of that kind, nothing beyond that. Okay, thank you. Boys, we will meet on some other occasion. Just 1 minute, please. 1 minute, please. Just 1 minute. I have one more decision. Let me see whether it is really relevant. I mean, for this today's, just 1 minute. ಒಂದೇ ಒಂದು ನಿಮಿಷ ಬರ್ತೀವಿ. More particularly relevant for sessions judges. This again is of a division bench. K. Pooja versus State of Karnataka. K. Pooja versus State of Karnataka. Date of judgment 22/2/2024. K. Pooja versus State of Karnataka. Date of judgment 22/2/2024. Again of a division bench. Criminal appeal 1291 of 2020. Criminal appeal 1291 of 2020 connected with 1297 of 2018. 1291 of 2020 connected with 1297 of 2018. Some more principles regarding this proof beyond reasonable doubt, circumstantial evidence. These things are highlighted there. Okay, thank you. We will meet on some other occasion.
Thank you, sir. On behalf of Karnataka Judicial Academy and on behalf of all the respected officers of Batch 1 and Batch 2, I wholeheartedly express my gratitude for enlightening on the new dimensions of BNS. Thank you, sir.